ರೋಮಮೋಹನದ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸುತ್ತಾ? ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಹಾ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. Yes.
$19. ಆಯ್ತು ನೋಡಿ. ನಿಮ್ಮ ಅಪೀಲ್ ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ರಿ? 19. ಮತ್ತೆ ಅಯ್ಯೋ ಕೆಟ್ ಫೈಟ್ ಫ್ರಮ್ ಲಾಸ್ಟ್ 4 years. ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಮೀಟ್ ಮಾಡ್ಬೇಕು ನೀವು. 4 ವರ್ಷ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೇಳ್ಕೊಂಡ್ರೆ ಆಯ್ತು. 4 ವರ್ಷ ಬೇಕಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ ನಾವು ಅರ್ಜೆನ್ಸಿ ಫಾರ್ ಯು. 4 years have not complied office objections. Now urgency for you. I told him, no, we'll see.
Number 7 and 1933.
Number 13. ಹೇಳಿ. ಯಾರು ಹುಷಾರಿಲ್ಲ? ಸೀನಿಯರ್ ಕೊಲೀಗ ಏನೋ ಡಿಕ್ರೀ ಟು ಎಕ್ಸಿಕ್ಯೂಟ್ ಸೇಲ್ ಡೇಟ್ ಅಂತಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. 544 days. ಅದರ್ ಸೈಡ್ ಕಲ್ಯಾಣ್ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 times on the ground that not keeping well. And also submits that already informed respondent counsel and hence list this matter after 2 weeks. 32 ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಬೋತ್ ಕೌನ್ಸಿಲ್ಸ್ took time. ಅವ್ರಿಗೆ BS ನಾಗರಾಜ್ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ಇಬ್ರಿಗೂ ಅದೇ ಬೇಕು, ಯಾಕೆಂದ್ರೆ ಇಬ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಿ. 2017 ಅಡ್ಮಿಷನ್ after 6 years also councils are not ready. ಏನ್ ಓನ್ಲಿ ಡೆತ್ ಬೆನಿಫಿಟ್ ಬಗ್ಗೆ ಇರೋದು ಅದು. ಮೋಸ್ಟ್ಲಿ ಅದು ಹೇಳಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್. I thought the respondent counsel 6 times and counsel also submits that he has already informed appellate counsel and then list after 2 weeks. After 2 weeks. 31 ಹೇಳಿ counsel. ನೇನ ಎಕ್ಸಿಬಿಟ್ P1 ಏನ ಕೊಡಬೇಕು ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ವಿ. appellate counsel 6 times to place the exhibit P1. List after 2 weeks. Then parted allala madam after 2 weeks. 37. 38 ಹೇಳಿ ಸೆಟ್ ಏನೋ ಆಯ್ತ್ರಿ. ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ನೋಡ್ರಿ, ಸೆಟ್ಲ್ ದಿ ಮ್ಯಾಟರ್. ಲಾಸ್ಟ್ ಟೈಮ್ he took time settle the matter. ಹೇಳಿ. ಮಂಡೆಗೆ ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ? ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 times is this matter next week ಅಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್. ಎಂಡಲ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಕೊಡಿ 17th. and council also submits that already informed other side council.
Number 51, my lord, appearing.
Yes madam. Ready. appellant counsel 6 time and counsel got already informed the appellant counsel and hence list after 2 weeks. 53 to 59. ಯಾವುದು? wait ಮಾಡಿ ಒಂದು ನಿಮಿಷ. 53 to 59. 60 and 61. ಹೇಳಿ ಏನು?
So error in the building. So off of the building charges, have to take one the. So they must the building of children.
ಸರಿ ಈಗ ಏನಾಗ್ಬೇಕೇನ್ರಿ? FDP ಆಲ್ರೆಡಿ ಇದೆ ಅಲ್ವಾ? ಯಾವ್ದ್ರಲ್ಲಿ ಎರರ್ ಇದೆ? ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್? ವಿ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ. ಲೋಯರ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎರರ್ ಇದ್ರೆ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು. ನಮ್ಮ ಮುಂದೆ ಮಾಡಿದ್ರು ನಾವೇನ್ ಮಾಡೋದು? FDP ಜಡ್ಜ್ಮೆಂಟ್ ನಾವೇನ್ ಕರೆಕ್ಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಅಪೀಲ್ ಇದೆಯಾ ಅದ್ರ ಮೇಲೆ? ಅಪೀಲ್ ಇದೆ. ಆಯ್ತು ನೋಡ್ರಿ, ಅದೇನ್ ತಗೊಂಡು ಡಿಸ್ಕೌಂಟ್ ಹಾಕ್ಸಿ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು? ಅರ್ಜೆನ್ಸಿ ಏನು ಒಂದೇ? RF ಏನು? RSA ಕೋರ್ಟ್. So the appellant counsel is absent and this appeal was filed in 2021. Till date objections not complied, office objection not complied. However, first time matters listed for non-compliance of office objections and hence 2 weeks time granted to comply with office objections. Venkatesh or Bhagat. Done. ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್? ಏನ ಇಲ್ಲ ಅಂತಲ್ಲ ನೋಡಿ, ಮೊದ್ಲೇ ಇರ್ಬೇಕು ನೋಡ್ರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಇಲ್ಲಿ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀನಿ ಅಂತ ಬಂದು ಯಾವಾಗ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಜಿಯೋಲಾಜಿಕಲ್ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರೋದು. ಅವೆರಡು ಅಟೆಂಡ್ ಮಾಡಿಲ್ವಾ? ಡಿಲೇಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಲ್ಲ ಡಿಲೇಗೆ, ಅದ್ಯಾಕೆ ರೌಂಡ್ ಅಪ್ ಮಾಡಿದಾರೆ? ಅಂಡ್ ದ ಡಿಲೇ ಆಫ್ 260 days ಇನ್ ಪ್ರಿಫರಿಂಗ್ ಅಪೀಲ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಇದರಲ್ಲಿ. ಅಪೀಲ್ ವಾಸ್ ಕೆಪ್ಟ್ ರೆಡಿ ಬೈ 19th but due to lockdown it could not be filed in time and necessary application is filed to condone the delay. Hence the regular second appeal is beyond time ಅಂತ ನಂಬರ್ ಬರ್ದವ್ರಲ್ಲ. ಮತ್ತೇನು ಅಬ್ಜೆಕ್ಷನ್ ಸರ್? ಇದು ಜಿಯೋಲಾಜಿಕಲ್ ಟ್ರೀ ಅನ್ನು ಹಾಕಿದೀನಿ ಅಂತಾರಲ್ಲ, ಎಲ್ಲಿದೆ ನಿಮ್ ಜಿಯೋಲಾಜಿಕಲ್ ಟ್ರೀ ಹಾಕಿರೋ?
ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಅದು ಬೇರೆ
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ವಲ್ಲ? ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ತೋರಿಸಿ ಅವ್ರಿಗೆ. ಎಲ್ಲಿದೆ ನೋಡಿ ಅದು. ಅದೇ ಯಾವಾಗ ಹಾಕಿದಿರಿ? ಇವತ್ತು ಬೆಳಗ್ಗೆ ಹಾಕಿದಿರಿ ಅದೇ ಹೇಳಿ. ಎಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಿ? ಬೆಳಗ್ಗೆ ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು. Appellant counsel submits that today morning he has filed a genealogical tree. And regarding second office objection in the limitation, and with regard to the limitation, the same is stated in the appeal memo, and hence the said objection is overruled. The registry is directed to verify the genealogical tree filed before the office, filed in the office, and put up the same. If office objections complied, post the matter for admission. Shivashankar K. Appellant counsel is absent and hence this appeal was filed in 2021 and till date office objection is not complied in spite of matter listed for second time. However, 2 weeks time granted on cost of ₹1,000 payable at registry, and if office objection not complied within 2 weeks and cost not paid, list this matter for dismissal on 24/2. Bias of BG. Same order. SV Prakash. 2 weeks time same order. ಎರಡು ವಾರ ಅಷ್ಟು. ಇದರ ನೋಡಿ ಮೇಡಮ್ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಗೊತ್ತಾಗ್ತೀರಾ? The council submits that genealogical tree is ready and he is going to file the same in the office today itself. And ಅದೇ ಇಲ್ಲಿ ಬಿಡಿ ಏನಾಗುತ್ತೆ ಅದಿದ್ರೆ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಹಾಕಿ ಮಾಡ್ಬೇಕು. And also council submits that IA filed by the appellant for condonation of delay is not pressed, and hence IA is dismissed as not pressed. And post the matter for admission. If office objection of filing of genealogical tree is complied. Andish Patil. For 2 weeks time of cast. Take it. Time. ಕೊಟ್ಟಿಲ್ವಾ? ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. 4ನೇ ಸರಿ ಬಂದಿದೆಯಲ್ಲ ಯಾಕೆ? ಯಾರ ಮುಂದೆ ಆಗಲಿ. Learned counsel for the appellant submits that appeal is in time and therefore request this court to reject IA1. ಆಯ್ತು. Said submission is taken on record. IA is rejected. 2 weeks time is granted to comply with office objections. ಏನ್ರಿ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು 2 ವಾರ. ಆಮೇಲೆ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಓವರ್ರೂಲ್ಡ್, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಂತ ಅರ್ಲಿಯರ್ ಇದೆ. 2 weeks time is granted to do the needful. ರೆಸಿಟ್ ಕೊಟ್ಟು ಕಟ್ಟಿಲ್ವಾ? ಅಲ್ಲ ರೀ, 4ನೇ ಸರಿ ಬಂದಿದೆ ಲಿಸ್ಟ್ ಮ್ಯಾಟ್ರು. ಎಷ್ಟು ಸರಿ ಆಗ ನೋಡಿ. another 2 weeks time granted and cost of ₹2,000. Serial number 9. Non-compliance of office objections, non-payment of cost. Serial number 9. List 2. Arumbaya TA. Hold. Madam, 24/1/23 granted 2 weeks time, not complied office objections and also not paid the cost, and in view of the preemptory order dismissed. Dismissal appeal, non-compliance of office objections. ಮತ್ತೆ ಟೈಮ್ ಕೊಡ ಪ್ರಶ್ನೆ ಇಲ್ಲ. preemptory order. This matter is of the year 2020 and the matter is listed for the first time for non-compliance of the office objection, and the office objections are not complied till date. However, in the ends of justice, 2 weeks time granted, learning counsel for this comply with office objections. If the office objections are not complied within 2 weeks, this matter for dismissal. 2020 ಇಸ್ವಿದು ಅಪೀಲ್ ಯಾವ್ದಾರು ಆಯ್ತು, ಮತ್ತೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಅಪೀಲ್? the preemptory order dismissed. preemptory order ಪಾಸ್ ಮಾಡಿದ್ರು ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ. 11 SM ಅನೀಸ್ ಅಹಮದ್. ಸೇಮ್ ಮೇಡಮ್ ತೊಗೊಳ್ಳಿ. preemptory order 24/1/23 2 weeks time 1,600 ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಕಂಪ್ಲೈನು ಮಾಡಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ಡ್. ಪಾರ್ಟಿ ಬರ್ಲಿಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ. ಮಾಡಿಲ್ಲ, ಆಯ್ತು. 24/1/23 preemptory order non-payment of cost and non-compliance of office objections. Dismiss. Compliance of office objections and IA 1 of 23. ಆಯ್ತು ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ. ಹೌದ್ರಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಫೈಲ್ ಮಾಡಿ ನೋಡಿ. Council 6 weeks time to comply with the office objections granted. Dismissal of appeal for non-compliance of office objections. ಮಾಡಿದಿರಾ ಯಾವಾಗ? 6/2 ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡಿದಾರ ಮೇಡಮ್ ನೋಡಿ. ಆಯ್ತು ಒಂದಿದೆ ಅಂದ್ರೆ ಅದು ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರೆ? ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಅಥವಾ ಮುಂಚೆನ? ಆದ್ಮೇಲೆ ಮಾಡಿದಾರೆ. ಕೊಡಿ ಇನ್ನೊಂದು. ಇನ್ನ ಏನಿದೆ ಇನ್ನೊಂದು? ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕಿಲ್ಲ. ಕೋರ್ಟ್ ಫೀ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ? ಅದೇನೋ ಇಲ್ಲ ಅಂತ ನೋಡಿ ಅದ್ರಲ್ಲೇನೋ. ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಿ? ಮತ್ ನಿಮ್ಗೆ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತಲ್ಲ ಅದು. ಏನದ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಥರ್ಡ್ ಟೈಮ್ ಮೇಡಮ್. ಇದು ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ? ಈಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ? ಏನು ಓನ್ಲಿ ಕೋರ್ಟ್ ಫೀ ಕೊಡಿ. ಅದೇನು
238
ಪೇಜ್ ನಂಬರ್? ಡಿಗ್ರಿನಲ್ಲಿ ಕಾಸ್ಟ್ ಇರುತ್ತೆ. ಅದೇ ನೀವು ಹೇಳ್ತಾ 238 ಅಲ್ಲಿ ಇಲ್ಲ. ನಮ್ಮ ಕಾಸ್ಟ್ ಬಗ್ಗೆ ಏನು ಹೇಳೇ ಇಲ್ವಾ? ಅಟ್ಲೀಸ್ಟ್ ಕೋರ್ಟ್ ಫೀ ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಹೇಳಿ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕಟ್ಟಿದ್ದು ಅಂತ? ಇಲ್ಲ ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ? ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಹಾಕಿದಾರ ಮೇಡಮ್ ಅಲ್ಲಿ? ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಲ್ಲಿ ಇರುತ್ತಲ್ಲ. Partition separate provision 35(2). ₹300 ಕಟ್ಟಿದ್ರಿ. ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಎಲ್ಲಿದ್ದಾರೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ನಿಮ್ದು? ಪೇಜ್ ನಂಬರ್ 316 ಬಂದ್ರ? ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಇದೆಯಲ್ಲ. Petty branch half share in all properties according to court of 2,200 is paid. ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ? ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Council submits that he has paid the cost and also complied with regard to the court fee. And council brought to notice of this court the payment valuation slip produced along with the appeal, wherein 300 rupees is paid before the trial court and accordingly has paid the court fee of rupees 300. And hence office objection regarding cost is not forthcoming in the decree is overruled. What's the matter for admission? Dismissal of appeal for non-compliance of office objections. Mandilaru. Madam, the preemptory order 24/123 dismissed. 2 weeks not complied on. Loknath R. First 24/123. 2 weeks not complied. Along 2 weeks normally. ಈಶ್ವರ ಭಟ್ ಹೇಳ್ರಿ.
Despite of my best effort, I could not get the copy of valuation report. But however, I have produced the copy of the claim. Kindly see page number 97.
Madam.
Otherly,
Non-filing of certificate of any proof on which value 40 of rupees 275 is paid. Since in certified copy of plaint, the value is not forthcoming until that.
I will make submission effort and I get submission. Kindly see page number 97.
97, I
Oh, the file number 50. For the purpose of jurisdiction, suit is valued for more than 1 lakh and hence within the jurisdiction of this honorable for the purpose of court fee, and the suit is valued as per section 7 read with section 35(2) of 38 and the court fees and suits valuation act. As the property is the revenue from the suit is valued as per the separate, but it is not even I could not get.
valuation step annexed to the memorandum plaint until.
I have applied for the copy in spite of even I am the third party also. Kindly see the decree position. That is the court fee is respected at page number 89.
It ಇದೆಯಾ?
Parallel decree ಅಲ್ಲಿ
ಕ್ಲಿಯರ್ಲಿ ಇದೆಯಾ?
ಇದೆ. Plaint is 75 at page number 89. Parallel.
89 or 275.
But even
I told you the council submits that he had applied for certified copy of the valuation slip and he could not get the same. The council brought to notice of this court a copy of the decree wherein cost of suit court fee is mentioned as rupees 275 and accordingly he has paid the cost. Hence, this objection is overruled. Matter for admission. In a ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
The plaint at bank.
ಅಲ್ಲ produce ಮಾಡಿದ್ದಾರೆ. Certified copy plaint
Plaint copy ಹಾಕಿದ್ದಾರೆ.
Any
Since in certified copy of plaint the value is not forthcoming ಅಂತ. But ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಬೇರೆದಕ್ಕೆಲ್ಲ ಕಾಸ್ಟ್ ಅಂತಾರೆ, ಕಾಸ್ಟ್ ಆಫ್ ಇದ್ರಲ್ಲಿ ಕಾಣಲ್ಲ ಅಂತಾರೆ, ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಆಫೀಸ್ನವ್ರೆ ಕಾಸ್ಟ್ ಅಲ್ಲಿ ಇಸ್ ನಾಟ್ ಫೋರ್ತ್ ಕಮಿಂಗ್ ಅಂತಾರೆ ಇಲ್ಲದ್ರಲ್ಲಿ. ಈಗ ಇದ್ದಿದ್ರಲ್ಲಿ ಇದೆ, ಅದನ್ನ ನೋಡಕ್ಕೆ ಇವ್ರಿಗೆ ಆಫೀಸ್ನವ್ರಿಗೆ
on which value court fee 275 is paid, clarify ಅಂತ.
ಅದಿದೆಯಲ್ಲ ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಕೋರ್ಟ್ ಮಾಡಿದೀವಿ ಓವರ್. Matter for admission. Okay, what is the urgency? ಆಯ್ತು.
and before the first of
Purchasers are also subject to the result of the suit.
already commission survey came and
ಆಯ್ತು, ಮಾಡ್ಲಿ ಬಿಡಿ, ಮಾಡ್ಲಿ.
submission
Huh.
there are 38 purchasers before your lordship
38.
there appellants before your lordship
Huh.
and makes
If any property is purchased during the pendency of the suit, they are bound by subsequent purchase.
after the death of 26 years from the date of death the party
ಆಯ್ತು, ಅದೆಲ್ಲ ಆಗೋಗಿದೆಯಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಆಗಿದೆಯಲ್ಲ RSA. Urgency.
16 become
I post this matter on 16 for admission. Hesha. Non-filing of application in respect of deceased appellant as per order dated. The appellant counsel again seeks 2 weeks time. Granted. Kumar K.R. Memo for retirement at flag A with respect to non-filing of necessary application with regard to bringing LRs of deceased appellant number 1. Veerabhadraya on record. Course, you know. Appellant number 1, Sri Veerabhadraya on record. ತಗೊಂಡಿದ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀವಿ ಅಂತ ಈಗ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ಹಾಕ್ತಿದ್ದಾರೆ ಕೌನ್ಸಿಲ್. ಹೌದಾ? ಪಾರ್ಟಿ ಹೆಸರು ವೀರಭದ್ರಯ್ಯ. ಹೇಳ್ರಿ ಏನ್ರಿ ಮೆಮೋ ನೀವು ಹಾಕಿರೋದು ಮೆಮೋ? ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಅಂತೆ? ಕೊಟ್ಟಿದ್ರಿ, ಬಟ್ ಎಲ್ಲಾಗಿದೆ? ಜಾರಿಯಾಗಿದೆ ಇದು? ನೀವು ಕೊಟ್ಟಿರೋದು ಯಾವಾಗಿದೆ? 1-2 ನಲ್ಲಿ. ಮತ್ತೆ counsel appearing for the appellant has not filed any acknowledgement for having served the retirement letter addressed to the appellant. and hence directed to produce the acknowledgement. List this matter on 24/2. Raghavendra Rao K. Yes. 27? 27/4 or 27/1?
ಅದೇನು ಈ ತರದಿಂದ ಇದು ಹೋಗಿದೆ ಆಕ್ಚುಲಿ ಅದು ಏನು ಕವರ್ ಅಂಡ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಇದೆ ಸರ್ ಅದು.
ಇಲ್ಲ.
ವಾಪಸ್
PF
ಬಂದಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ ವಾಪಸ್
ಅದಾಗಿರೋದು 21 ಅಲ್ಲಿ ಸ್ಟಪ್ ಮಾಡಿರೋದು.
21 ನಲ್ಲಿ
PF ಎಲ್ಲ ಕೊಟ್ಟಿರೋದು ನಾನು 19 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
2019 ಅಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರೋದು ಯಾವಾಗ ಮೇಡಮ್ PF? 19 was issued. You have to take fresh steps. Acknowledgement was not returned. Good. The appellant counsel seeks 2 weeks time to furnish the PF. Issue notice to R4. And if PF paid within 2 weeks, issue notice to R4. Notice to R1, R2. Week counsel seeks 1 week time. And if PF paid within 1 week, issue notice to R1 and R2. ಆಮೇಲೆ steps to be taken in respect of deceased R3. ಅವು ಯಾವಾಗ ತೀರ್ಕೊಂಡಿರೋದು? 1 week ಟೈಮ್ ಆಯ್ತು ರೀ. ತೀರ್ಕೊಂಡಿರೋದು ಯಾವಾಗ? ಅಬೇಟ್ ಆಗಿರ್ಬೋದು ನೋಡಿ. ಯಾವಾಗ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್. 19 ಅಲ್ಲಿ ಬಂದಿರೋದು. ಆಮೇಲೆ ಹೆಸರು ಲಿಸ್ಟ್ ಆಗಿದೆ. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆಯಾ? ನೋಟಿಫೈ ಆಗಿದೆಯಾ? ಇಷ್ಟ ಆಗಿಲ್ಲ. 31/5 ಅಂದ್ರೆ ಯಾವ ಇಯರ್? 19 ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದ್ದೆ ಅವಾಗ ಮೇಡಮ್. ಡೆತ್ ರಿಪೋರ್ಟ್ ಆಗಿದ್ದೆ ಅವಾಗ. ಅಲ್ಲ ಮೇಡಮ್, ಸತ್ತೋಗಿದ್ದು ಅಂತ ರಿಪೋರ್ಟ್ ಆದ್ಮೇಲೆ ಆಫೀಸ್ನವ್ರು ಇಷ್ಟು ವರ್ಷ 4 ವರ್ಷ ಇಟ್ಕೊಂಡ್ರೆ ಹೆಂಗ್ರಿ ಮೇಡಮ್? ಹೌ an advocate comes to know about that it was reported as dead ಅಂತ? The appellant counsel seeks 2 weeks time, 2 ಮಾಡಿ 1 ಬೇಡ, 2 weeks time to ascertain the correct address and take steps against R3. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್ ಆಫೀಸಲ್ಲಿ ಕೇಳಕ್ ಕೂತ್ಕೊಂಡು? ಈ ರಿಪೋರ್ಟ್ ಆದ ತಕ್ಷಣ ಇದು ಸ್ಟೆಪ್ಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ವಾ? 4 ವರ್ಷ ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ ಇದು? ಒಂದ್ಸತ್ 4 ವರ್ಷ ಆಗಿದೆ. Time granted. 2 weeks ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. Notice to R3, 1 week. The appellant counsel seeks. ಇದು ಯಾರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ? ಯಾರು ರಿಟರ್ನ್ ವಿತ್ ಪೋಸ್ಟಲ್ ಶರ R4. ಆಯ್ತು, ಇಬ್ರಿಗೂ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ. 2 ವಾರ ಕೊಡ್ತೀನಿ, 1 ವಾರ ಬೇಡ, 2 ವಾರ ಅಸರ್ಟೈನ್ ಮಾಡಿ ಅಡ್ರೆಸ್ ತಗೊಂಡ್ ಮಾಡಿ. Appellant counsel seeks time to pay PF. Issue notice to R3, and also the notice issued against R4 was returned with an endorsement. He is no more, and hence 2 weeks time granted to take steps against LRs of R4. If that's not taken, list this matter on 24/2. Balakrishna Shastri, issue notice to R2 for second time. Counsel 6 weeks time to pay PF. If PF paid, issue notice to R2. Krishna Swami, yes.
Please, 2 weeks kodi Swami.
The counsel 6 2 weeks time to pay PF. If PF paid, issue notice to R1.
Oblige man.
Counsel 6 weeks time. If PF paid, issue notice to R1. Mahesha, notice to R2 and R5. The counsel 6 2 week 1 week 1 week time, 6 1 week time, and if PF paid within 1 week, issue notice to R2 and R5. Umesh, paper book ಆಯ್ತು, ಫಸ್ಟ್ ನೋಟಿಸ್ ಹೇಳಿ. counsel 6 2 weeks time. 2 weeks ಹಾಕ್ಬೇಕು PF ಕೊಡಕ್ಕೆ. ಸೇಮ್ ಅಡ್ರೆಸ್ ಕರೆಕ್ಟ್. ಪೇಪರ್ ಬುಕ್ ಹಾಕದ ಆಮೇಲೆ ಹಾಕಿ ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು ಪೇಪರ್ ಬುಕ್ಕಿಗೆ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಆರ್ಡರ್ ಶೀಟ್ 21 ಅಲ್ಲಿ 8 weeks ಆಮೇಲೆ ಮತ್ತೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ಳಿ while admitting the appeal in 21 8 weeks time was given to file paper book. Until that paper book not filed, counsel seeks 2 weeks time to file the paper book. The counsel also seeks 1 week time to pay the PF, and if PF paid, issue notice to R2. Non-furnishing of PF, correct address, etc. to issue notice to R2. Putira, the counsel submits that during the course of the day he would pay the PF, and if PF paid, issue notice to R2 A to D. Rajagopal Naidu, furnishing of PF correct address, issue notice to R2, R3, R8, R9, R11, and R13 third time. Ilva? Respondent. Family members, sir? 65 ಇಂದ ಇನ್ನು ಕೋರ್ಟಲ್ಲ ಇದಾರ ಪಾರ್ಟೀಸ್ 65ರಿಂದ ಇದಾರ ಆಯ್ತು ಬರ್ತಾನೆ ಇಲ್ಲ ಮೇಡಮ್ ತಗೊಳ್ಬಿಡಿ ಯಾವಾಗ ಇದು ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು ಥರ್ಡ್ ಟೈಮ್ ತಗೊಳ್ಳಿ appellant counsel is absent and PF also not paid even when the matter is listed for third time to issue notice against R2, R3, R8, R9, R11 and R13. And 2 weeks time given to take the steps. And if PF not paid within, and if PF paid, issue notice against R2, R3, R8, R9, R11, and R13. And if PF not paid within 2 weeks, appeal will be dismissed against same R2 to the same non-compliance of office objection raised on IA 1 of 21, that is copy not served on other side. What is that IA? Stay na. The counsel also given 2 weeks time to comply with office objection on IA 1 of 21. Antarajappa MG.
I appear for appellant. Await notice of
R123. 6-2 issue agirada. First week of March kodi.
Interim matter may be extended, my lord.
10th of March. List this matter on 10th of March and interim order granted earlier is extended till then.
Please.
Applications. Prasanna VR for appellant and also for proposed LRs of deceased appellant. One of our days in filing LR application, madam. LR application में notice होगी दिया. Bring the LRs of deceased appellant 1 year na. Other side are ilva. You know, delay for filing up. ಇನ್ನೊಂದೇನ ಇದೆ for delay 1233 days. R4 gala issue notice on IA number 4 of 22, 5 of 22, 6 of 22 against the LRs of deceased R4 ಒಂದಾಯ್ತು ಆಮೇಲೆ 9 R11 issue notice against the LRs of R11 and IA 7 of 22, 8 of 22, 9 of 22. The counsel appearing to the appellant also filed memo treating R5, R6 and R8 to 10 as the LRs of deceased R7, and hence memo is accepted and appellant counsel is directed to amend the cast title in terms of the memo. Perusal of covered with postal shara as unclaimed ಆದ ಒಂದಿದೆ ನೋಡಿ R2 and R3 ಏನಾಗಿದೆ intimation ಹೋಗಿದ್ಯಾ? The notice issued against R2 and R3 returned with an endorsement unclaimed, and on perusal of postal cover intimation was delivered and in spite of it not claimed, and hence held sufficient against R2 and R3. Right alla? ಬಾಕಿ IAS ಎಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ ಅವ್ರ ಅಪಿಯರ್ ಫಸ್ಟ್ ಅಪಿಯರ್ ಆಗಲಿ. Vishwanath R. Hegde.
Lord, I appear for the appellants, Lord.
Ah.
Notice was ordered on IA number 1 of 21, IA 2 of 22, and IA 1 of 22. They are served, my lord, and they are now represented by a learned advocate. Now, the applications may be allowed, my lord. I may be permitted to amend the cost title.
You are LRs of R1A2F. Heard on IA 1 of 22. There is a delay of 211 days in filing the LR application, and IA 2/22 for setting aside abatement, and IA 1 of 21 for bringing LRs of deceased R1 as R1A2F. And this court has issued notice against the LRs, and the LRs are also represented through counsel. And counsel appearing for the LRs also not disputes the relationship between the parties and says no objection, and hence IAs are allowed and delay is condoned, and abatement is set aside and permitted to bring the LRs on record. The appellant counsel is directed to amend the cost title and file amended appeal memo within 2 weeks.
Please, Lord.
Next ಇನ್ನೊಂದು ಏನಿದೆ ನೋಡಿ. Memo dated 13/7/20 filed by advocate for caveators. The photographs ಅಷ್ಟೇನಲ್ವಾ?
That may be considered along with him.
ಅದಾಯ್ತು, ಅದೇನು ಈಗ ಬೇಕಾ ಇಲ್ಲ.
Please.
ಆಯ್ತು. The memo dated 13/7/21 and 10/3/21 will be considered along with the main appeal. ಅಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಹೆಂಗ್ ಮೆಮೋದಲ್ಲಿ ಹಾಕಕ್ ಬರುತ್ತ್ರಿ? ಆಯ್ತು. Post the matter for admission up to 2 weeks.
Please.
H.N. Shashidhara, NOC, Kemparaju. ಈಗ ಎರಡು ಡಿಲೀಟ್ ಆಗಬೇಕು, ಶಶಿಧರ ಅಂಡ್ ಕೆಂಪರಾಜ್ ಎರಡು. NOC ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. The registry is directed to delete the name of counsel H.N. Shashidhara, which has been designated as senior counsel, and counsel Sri Kemparaju has already given NOC, and counsel H.S. Suhas has filed wakalat with NOC na with NOC. I think again next IA 1/23 for
JMFC in I basis of the chapter. August square. Those documents are required. I had filed that. Other street documents. They have my court dismissals regularly. There is a reverse step or I will arrest. Those 3 checks I had sought to produce with the magistrate. This honorable court rejected that application that I filed. For the reason that there is no provision to provide such another. Now, since that is set down for evidence.
Now we can obtain certified copy and mark it before the trial court.
Documents. Especially the checks.
Certified copy.
Because the reason is that when the checks paid into it's not coming out. Maybe someone back time of fighting. That is why it did not work. It was trial. He has tried and complete loss of check and other thing against the respondent, and he can very well. I have also produced that those checks by obtaining this earlier he can very well produce the certified copy of both checks which are marked.
Any dispute with regard to the issuance of any check itself? That is maybe last, whether signature available on document that is in the check. Any dispute? Huh? No dispute. Then why you want the original copy?
Not this time. Any question? This prosecution able to go ahead with the case.
Why?
Because they have expressed something.
Then let them produce the certified copy, that's all. If any dispute with regard to the signature found on the check. Then original is required, or otherwise you can place it certified copy.
On the check can only be seen in the color. That is the certified copy earlier. Now this problem is the certified copy is created. It legible. What is
Even if we send this document, if it is marked before the trial court, then again we have to get back the documents. And then again, we have to send that document to the particular court while disposing of the matter. You can place it the certified copy. That's enough.
that is my only submission I can give.
You are disputing the ratings made on the check.
Is ready. Michael.
ಆಯ್ತು ಕಳ್ಸೋಣ ಬಿಡ್ರಿ, ಮಾರ್ಕ್ ಮಾಡ್ಲಿ, ಒರಿಜಿನಲ್ ಮಾರ್ಕ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ಅಲ್ಲಿ ಆಯ್ತು ಬೇಕಾಗುತ್ತೆ. ಆಯ್ತು, ನೀವೇನು ನಮ್ಮ ಇದರಲ್ಲೇನು ಇಲ್ಲಿ ಬೇಗ ಡಿಸ್ಪೋಸಲ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಇಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಆಗಿದೆಯಾ? ಆಯ್ತು, ಇಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಆಗಿದೆಯಾ? ಅವ್ರಲ್ಲಿ ಇದರಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವೇ ಹಿಯರ್ ಮಾಡೋಣ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದ್ದ. I will fix the date for final hearing and I will dispose of this RSA. Now, why you have to keep this matter pending? Padbodalla. I told. This matter is admitted. And also paper book is filed. And both the councils have filed 2 applications. One is for withdrawal of the amount in deposit and also for transmission of records to the criminal court. And instead of considering these 2 IAs, matter can be heard and disposed of on merits. And hence list this matter on 20th of February. Agoda? 20th of February. Here man dispose man. Right. JIMN. ನೀವು ಪ್ರಪೋಸಲ್ ಯಾರಿಗೆ ಕೊಟ್ರದು? ಪಾರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನ್ರಿ ನಿಮ್ ಪಾರ್ಟಿ ಹೇಳಿದಾರೇನ್ರಿ? ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕು, ಕೇಳಿ ಹೇಳ್ತೀರಾ? ಆಯ್ತು. ಚಂದ್ರಕಾಂತ್ ಆರಿಗ, ಡೈರೆಕ್ಷನ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪ್ಲೆಂಟ್ ಅಲಾಂಗ್ ವಿತ್ ಸ್ಟೇಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಏನ್ರಿ ಅದು? ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ. Yeah, non-compliance of office objections raised on paper book filed by advocate for appellant, that is certificate not forthcoming in paper book. Certificate hakilla antalri. Paper copy not produced in paper book. Eradu office objections ide nodi paper book. Pass over ಮಾಡಿ ಏನು ಮಾಡ್ತೀರಿ? ಸರ್ಟಿಫಿಕೇಟ್ ನೀವು ಹಾಕ್ಬೇಕು. ಏನೋ ಒಂದು ಡೈರೆಕ್ಷನ್ ಯಾರು ಕೇಳಿದ್ರಲ್ಲ, ಏನೋ ಅಪಲೆಂಟ್ ಏನ್ ಡೈರೆಕ್ಷನ್ ರೀ ಅದು? ಟೆಂಪ್ರರಿ ಇಂಜಂಕ್ಷನ್. ಟೆಂಪ್ರರಿ ಇಂಜಂಕ್ಷನ್ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಹಾ ಹಾ, ಏನ್ ಟೆಂಪ್ರರಿ ಇಂಜಂಕ್ಷನ್ ಏನು? ಏನ್ ಟೆಂಪ್ರರಿ ಇಂಜಂಕ್ಷನ್ ರೀ? ರಿಸ್ಟ್ರೈನ್ಡ್? One of 20 is allowed. Respondents are restrained from interfering with the peaceful personal enjoyment of social property by the defendant. So and so. ಆಯ್ತು, ಈಗೇನ ಮತ್ತೀಗ ನಾವು ವಾಟ್ ಇಸ್ ದ ಪ್ರೇಯರ್? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ನಿಮ್ ಪರವಾಗಿ ಹಿಂದೆ. ಈ ಪ್ರೇಯರ್ ಏನಂದ್ರೆ ಡೈರೆಕ್ಷನ್ ಪೊಲೀಸ್ ಫೋರ್ಸಾ? ಯಾಕೆ ವೈ ವಾಂಟ್ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್? ಅಯ್ಯೇ ಕೊಡಿ ಮೇಡಮ್. Yes, what is the objection? If you have not objected, if police force is given, what is there? Come on, if you are not objecting it for cultivation of the land, the suit is for specific performance. Okay. Anyhow, subject to the result of this appeal, whether specific performance or for granting of earnest money. Heard. And I 1 of 22 for direction. And in the application sought for police protection, contending that in spite of this court passed an order of temporary injunction against the defendant in interfering with peaceful possession and enjoyment of the property, which is the subject matter of the appeal, and the respondents are interfering and troubling. And to that effect, an affidavit is filed, but counsel appearing for the respondent would contend that no such interference is made by the respondent, and they are not interfering with the peaceful possession of the appellant herein. ಅದೇ ಸಬ್ಮಿಷನ್ ಸಾಕಲ್ಲೇನ್ರಿ? ಮತ್ತೆ ಸುಮ್ಮನೆ ಅಲ್ಲಿ ಪೊಲೀಸ್ ಕರ್ಕೊಂಡು ಹೋಗಲ್ಲ. ಅವರೇ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, ವಿ ಆರ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ಅಂತ. ವಿಲ್ ಪ್ಲೇಸ್ ದಿ ರೆಕಾರ್ಡ್. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ ಅಂತ ತೋರಿಸಿ. ಆಯ್ತು. ಆಯ್ತು, ಏನಾಯ್ತು ಮೇಡಮ್? ನಾಟ್ ಇಂಟರ್ಫಿಯರ್ಡ್. And the allegations made in the application and affidavit is false. And in the statement of objection and also the submission, counsel reiterate the same. Having heard the respective counsel and also on perusal of material, this court already granted an interim order on 28/9/21, restraining the respondents not to interfere with the peaceful possession and enjoyment of the property of the appellant. And the very contention of the appellant that in spite of the order, they are troubling the appellant. And in view of the affidavit filed by the appellant and though the respondents have denied the interference, it is appropriate to direct the concerned police, if necessary, provide the assistance as sought in the application. And accordingly, IA is disposed of. Ganapati Subraya Bhatt, IA 3/22 bringing LRs of deceased appellant number 1. ಏನ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಾದ್ರು ಇದೆಯಾ ಐಎಗೆ? ಏನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯಾ? ಅದು ತೊಳ್ತೀನಿ, ಬಟ್ ಅವ್ರು ಎಲ್ಲಾರು ಸೌತ್ ತಾನೆ, ಎಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲಲ್ಲ. Heard on IA 3/22 for bringing LRs of deceased appellant number 1. And there was a delay of 89 days in filing the application. And counsel appearing for the respondent orally opposed the application, contending that there was a delay of 89 days. Having heard the respective counsel and for the reasons mentioned in the IA, and appellant passed away, appellant number 1 passed away during the pendency of this appeal, and delay of 89 days is condoned for the reasons mentioned in the affidavit, and permitted to bring the LRs of appellant on record. Hence, appellant counsel is directed to amend the cast title and file amended appeal memo within 2 weeks. Admission ಬರ್ಲಿ ಅವಾಗ ಏನು ನೋಡೋಣ. ಮೂವಿಂಗ್ ಅಷ್ಟೇನೆ, ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಹಾಕೋಣ. ಆಯ್ತ್ರಿ, ಪ್ರೊಸೀಡ್ ಆಗ್ಲಿ, ಅಡ್ಮಿಷನ್ ಪೋಸ್ಟ್ ಮಾಡೋಣ. ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಐಎ. ಆಯ್ತು, ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಆನ್ 24/2 along with ಐಎ 24/2. ಇನ್ ಟೈಮ್ ಮತ್ತೆ 89 days ಡಿಲೇ ಇದೆ ಅಂತಾರ. ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಇದೆಯಾ? ಅದು ಒಂದೇ ಐಎ ತಾನೆ ಅದ್ರಲ್ಲಿ ಇರೋದು? ಒಂದೇ ಐಎ ಇರೋದಲ್ಲ ಮೇಡಮ್? ಒಂದೇ ಏನಲ್ಲಿ ಈಗ ಹಾಕ್ಬೋದಲ್ಲ ಮೂರನ್ನು?
ಸೆಪರೇಟ್ ಐಎಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಸಪರೇಟ್ ಐಎಸ್ ಹಾಕಿದಾರ? ತೋರಿಸಿರೋದು ಒಂದೇ ಐಎ ಅಲ್ಲ ನಮ್ಗೆ? ಎಲ್ಲ ತರೋದಕ್ಕೆ ಒಂದ್ ಐಎ ಹಾಕಿದೀರಾ? ಎಷ್ಟು ಹಾಕಿದ್ದೀರಾ? ಐಎ ಅಂತಾರ, ಮೂರಿದೆ ಅಂತಾರ. ಮೂರ ಐಎನಲ್ಲಿ ಒಂದ್ ಐಎ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಇದೆಯಾ? ಡಿಲೇ ಕಂಡೌಂಡ್ ಇದೆಯಲ್ಲ, ತೆಗ್ದ್ಬಿಡಿ ಮೇಡಮ್. ಐಎ ಇಸ್ ಅಲೌಡ್ ಫಾರ್ ಬ್ರಿಂಗಿಂಗ್ LRs ಅಂತ ಹಾಕೋಬಿಡಿ ಅಷ್ಟೇ. ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಬರ್ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು. ಅಬೇಟ್ಮೆಂಟ್ ಬರೋದೇ ಇಲ್ಲ, 90 days ಆಗೇ ಇಲ್ಲ. ಹಾಕಿದ್ರಿ, ಆಯ್ತು ಆಯ್ತು. ಅದೇನ್ ಅಪೀಲ್ಗೆ ಹಾಕಿರೋದ? ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ, ಇಲ್ಲಿ ಆಯ್ತು. ಕಂಡೋನೇಷನ್ ಏನ್ ಪ್ರಶ್ನೆ ಬೇಡ, 89 days ಏನು ಬೇಡ, ಓನ್ಲಿ IA 3 ಅಷ್ಟು ಬರ್ಕೊಳ್ಳಿ. 20 ಏನು ಪೇಪರ್ ಬಂದ್ ಹಾಕಿದಾರ? ಆಯ್ತು. The appellant counsel submit that paper book is filed yesterday in the office. ಏನು IS ಏನು? Proof for filed by advocate for appellant. ಎಲ್ಲ TI ನೇನಾ ಹಾಕಿದೀರಾ? ನೋಡಿ, the counsel appearing for the appellant respondent submit that he has filed objections to IA number ಏನಿಲ್ವಾ? ಬರೀ 39 IA 1 of 2 of 20 IA 1 of 22ಗೆ ಕಾಪಿ ರಿಸೀವ್ ಮಾಡಿದಿರಲ್ಲ ನೀವು? ಒಂದು appellant counsel also has received the copy of statement of objections. ಹೇಳಿ, ರೆಡಿ ಇದೀರಾ ಏನು?
This is the third defendant's, second appeal. No, admitted on the law. Whether the 1/4 share alienated by the father, which belongs to the appellant, is sustainable in law. The substantial.
Already substantive question of law is also framed. Right. Now, what is the prayer now?
Not I.
Aiming through or under him in any capacity whatsoever from putting up any construction or the extent equivalent to 1/4 share of the appellant. Applicant is the social properties described here in any manner whatsoever pending disposal of the above. ಹೇಳಿ.
One. He is the first responder from alienating that is my side. And I number 2 of 2020 got the I number 1 of 2020 is regarding the share. And I number 2 of 2020 is
IA 1 of 20 whether it is considered or not at the time of admitting the appeal.
but payment of the compensation amount is the second item of stock. But that is now started because we started.
Now you are pressing IA 1 of 22 or all IAs?
Only I number 2 of 2020 to restrain alienation.
Not to alienate. ಆಯ್ತು, not to alienate your share. ಆಯ್ತು, ಆಮೇಲೆ
So far as my
again whether they have taken up any construction. Statement of objections ಜೊತೆ ಫೋಟೋ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ಕೊಡಿ ಮೇಡಮ್.
is a one single house which the place here constructed. So that is the portion of the occupying about 10 meters of it. But the remaining action was
Well, now what you are praying this court to restrain him from putting up construction? Where is the material that they have taken up construction other than this house? You already ಮನೆ ಕಟ್ಟಿ ವಾಸ ಇದ್ದಾರೆ. ಆಯ್ತು.
my father has told money of there also.
ಆಯ್ತು.
The document, the first respondent along with the objection. That is the second document at page 6. Conversion order including my check. On the entire extent of 1 acre to Mita. He has the page 11 kind of. That is the layout plan. He has got the plan sanctioned for the entire extent of 1 acre to Mita. And otherly at page 9. Now we kindly peruse the subject. Say, Shimoga Talu Alcohol Gram Salon Effort for Vistina. 1 acre Yaransuke. Pradesh Sri Raju is Odaya Shimoga. Vasati Payovaki Karun Vinyasa Lakshe, ready to.
ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಫುಲ್ ಎಕರ್ 2 ಗುಂಟಾಸ್ಕೊಂಡು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ. ಆಯ್ತು. So ಈಗ not to alienate with regard to the appellant share ಅಂತ ಮಾಡೋಣ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ಪೈ ಸ್ಟೇಟಸ್ ಮೀನಿಂಗ್ ಇಲ್ಲ. ಸ್ಟೇಟಸ್ ಅಂದ್ರೆ ಏನು ಹೇಳಿ? How you can sell the share of his property? You also got it sanctioned to the extent of 1 acre 2 guntas. Otherwise, it will be a multiplicity of proceedings. Sir. If you execute the sale deed in respect of other area also, it would lead to the multiplicity of proceedings. What is the prejudice caused to you in restraining not to alienate the property with regard to the extent 10 guntas ಬರುತ್ತೆ ಅವನಿಗೆ 1/4 ಶೇರ್ ಅಂದ್ರೆ 1 ಎಕರೆ 2 ಗುಂಟೆ ಇದೆ 2 ಗುಂಟೆ ಬಿಟ್ಬಿಡಿ ಆಗ್ಲಿ 2.5 ಎಷ್ಟು 10.5 ಗುಂಟೆ ಬರ್ತದೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ ನೀವ್ ಹೆಂಗೆ ಎಂಜಾಯ್ ಮಾಡಕತ್ತ ಅವನ ಆಸ್ತಿನ ತಾವ ಮಾಡ್ಕೊಂಡು ನೀವ್ ಯಾರು ಇದ್ರಲ್ಲಿ ಮಗನ ಸೊಸೆನ ಮಗನೇ ಸೇಲ್ ಯಾರು ಮಾಡಿದವ್ರು ಯಾರು ಫಾದರ್ ಬೇರೆಯವ್ರದೆಲ್ಲ ಸೇರಿಸಿ ಫಾದರ್ ಇಲ್ಲ ಇವ್ ಮಾತ್ರನು ನೀವು ರಿಲೀಸ್ ಡೇಟ್ ಬರ್ಸ್ಕೊಂಡು ಸೇಲ್ ಮಾಡ್ಬೇಕು ಅದಿಲ್ಲ ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ಅಲ್ವಾ ನೋಡ್ ನೋಡ್ ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇರ್ಲಿ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು ಓನ್ಲಿ ನಾಟ್ ಟು ಪುಟ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂಡ್ ಆಲ್ಸೋ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಷ್ಟೇ ಆಫ್ ಹಿಸ್ ಶೇರ್. ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಏನಾಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ partly decreed, partly allowed granting defendants 1 to 6 are restrained by an order of permanent injunction from interfering with plaintiff's possession and enjoyment of suit scheduled property. Suit against defendant stands dismissed. Injunction ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. ಆಯ್ತು, injunction was granted. So this suit is filed by whom? First respondent is purchaser. Appeal alli modify ಆಯ್ತಾ? Partly allowed. ಅದನ್ನ the plaintiff is the absolute owner in possession of 1 and 2 of suit schedule A property. Permanent prohibitory injunction is hereby granted, restraining the defendant number 1 to 16 from interfering with peaceful possession and enjoyment of A schedule property. The plaintiff is entitled for the cost. Appeal filed by whom? Defendants,
I'm the third defendant.
You are the third defendant. Venkataramanayya. There are original suits ಎರಡು ಇದೆಯಲ್ರಿ. Heard the appellant counsel an IA 1/22 wherein he has sought for an order of temporary injunction not to put up construction in respect of his 1/4 share. Oda his 1/4 share. And also filed an application IA 2 of 20 for temporary injunction restraining the defendants, restraining the respondents to alienate, not to alienate the property of his share of 1/4 share in the suit schedule property. You had to objection and counsel appearing for the respondent has filed objection statement stating that already construction was completed. He has been in possession and also in support of his contention also produced the photographs. The total extent he has purchased is 1 acre 2 guntas. 1 acre 2 guntas. Total extent 2 guntas. And also produced the document for having converted the land which he has purchased and also formation of layout. along with statement of objections. And content that if an order of injunction is granted in favor of the appellants, it will cause prejudice to the respondent. Having heard the respective counsel and also on perusal of material, dispute is with regard to selling the property in the entire land of 1 acre 2 guntas. And in the said sale deed, the appellant is not a party to the proceedings. Not party to the sale, party to the sale. And father had sold the property after having got it released the property by other his 2 sons. But no any release deed is executed by the appellant herein. And the right of this appellant is affected on account of executing the sale deed by the father. Having taken note of the said fact into consideration, and also it is not in dispute that sale was made, and dispute appellant is not a party to the said sale. Under the circumstances, it is appropriate to direct the respondents not to alienate the property of the appellant, which is entitled for 1/4 share out of 1 acre 2 guntas, and also not to put up any construction as sought in IA 1 of 22, or otherwise it will leads to multiplicity of proceedings. The council note submits that already construction was made and photograph is also produced. And in out of total 1 acre 2 guntas, he has constructed a house. One house and no other construction was made, and hence restrained the respondent not to put up in respect of 1/4 share of the appellant in the disposal of this appeal. And accordingly, IA 1 of 22 and IA 1 of 20 are allowed. Divergent pending. Divergent pending.
That's
Hearing interlocutory application idea. I post the matter for admission along with IAS on 24/2 and 24/2. This is a delay 286. Post this matter for admission along with IAS on 24/2. ಯಾರು ಅದರ್ ಸೈಡ್ ಇದಾರ ಕಂಟೆಸ್ಟಿಂಗ್ ಯಾರು ಮತ್ತೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರೆ ಅದರ್ ಸೈಡ್ಗೆ ಮಾಡಿದಿರಿ ಬೇಡ ಇಲ್ಲಿ ಈಗ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋ ಅಡ್ವೊಕೇಟ್ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಅಕ್ಮಲ್ ಪಾಷಾ ಫಾರ್ R4 to 7 and 9 11 to 14 16 ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ. ತಗೊಳ್ಳಿ. An urgent, what is the urgency? 2009 suit. Heard the appellant counsel on IA 1 of 23 for early hearing, and copy is also served on the other side counsel and not filed any objections. And counsel would submit that this is the suit was filed in 2009 and the same was disposed of in 2014, and appeal also disposed of in 21, and matter is pending in the court from long time, and almost a decade has been elapsed, and hence taking into note of the grounds urging the application, IA is allowed and fix the date for and the date is fixed for final hearing on 24/2. Paper book ಎಲ್ಲ ಹಾಕಿದಿರಲ್ಲ ಅಲ್ಲ ಹಾಕ್ಬಿಡಿ. And already paper book is also filed, and hence list this matter for on 24/2.
Declare. Now, the Lord, your Lordship will get what are the issues that were before the trial.
Issues is with regard to the relationship between the parties.
So, after release, the respondent number 2 hearing, wherein some terminal benefits of the state came in.
ಮಕ್ಕಳಿಗೆ ಬರುತ್ತೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
My point is this one. First point
ಆಕೆ ಕೊಟ್ಟಿಲ್ಲ. Plaintiff number 2 and defendant number 1, 2, 3 and also the 1/4 share ಮಾಡಿದ್ದಾರೆ.
Once the marriage itself is void, there is no documentary. Respondent number 1 is legally wedded wife of the appellant, in the deceased husband of the appellant. Where was the question of granting such leave? Respondent.
Yeah, they are the children. ಏನಂತ?
The same thing. Very voter's ID that she has produced is not in the name of her husband. NCR just put clearly demonstrate nothing problem. ಈ voter's ID ಅಲ್ಲೇ ಎಷ್ಟು ಮುನಿ ವೆಂಕಟಪ್ಪ ರೆಡ್ಡಿ ಇದೆ ಬೇರೆ ಹೆಸರು ಮುನಿ ವೆಂಕಟ ರೆಡ್ಡಿ.
ಸ್ಕೂಲ್ ಎಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ಏನಿದೆ ಮಕ್ಕಳದ್ದು? ಮಕ್ಕಳ ಹೆಸರೆಲ್ಲ ಏನಿದೆ ಅಂದ್ರೆ ಫಾದರ್ ನೇಮ್ ಮಕ್ಕಳು ಸ್ಕೂಲ್ ಅಡ್ಮಿಟ್ ಅದರಲ್ಲೂ ಒಳ್ಳೆಯದು. Secure the registry is directed to secure the records of trial court and also the appellate court and list the matter along with trial court records for admission. ಏನ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನ್ ಸ್ಟೇಜ್ ಯಾರು ಇಲ್ಲ ಅದಿನ್ನೂ ಮಾಡಿಲ್ಲ ಇನ್ನು 1/4 ಅಂತ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. No counsel, let the records. Let the records come. Counsel, children are entitled for share. We'll consider it on Venkatappa Reddy or Venkata Reddy and also other material along with. We consider appeal. Necessary. No, counsel. No, counsel. I'm not sitting here to stall the proceedings. Records purely. ಯಾವ ಊರು? List this matter on 24/2. Yes, Vaikyan Sharma.
Yes, my lord. I appeal for the appellant.
Yes,
This is a matter your lordship heard. I tried to make out some point. After verifying the records, I took time. I'm sorry. I made your lordship to call for the records. Here records nodidini. Adalli there only 2 points, my lord. One is that Sampatamma, the daughter, is not made a party. That has been stated in the grounds of appeal in RA itself. Facts first the suit was filed for partition on 6/2/2014 and it is decreed 4/8/2015 ex parte. The difficulty was that he engaged an advocate but did not file return statement, and based on the evidence of PW1, suit is decreed. Appeal was filed and they did not file a miscellaneous petition. In the appeal, they filed an application saying that condonation of delay, saying that my brother was in charge, he was not well, and so we could not do it, and we could not secure documents, and we could not instruct the advocate. So that is how opportunity may be given. That is not accepted by the first appellate court. They dismissed the IA itself. Based on that, main appeal is dismissed. Now, 2 points are this, my lord. One is Sampatamma, without making a party, whether a partition suit could be decreed. That is number one. For that, your lordship observed that it could be taken up in the FDP. But FDP that of course I will not challenge that observation of your lordship or dispute that observation. It is possible But once a preliminary decree is finally disposed of and all that, they may take up a defense saying that now you cannot because there is no change of circumstance. Change of circumstances, I understand FDP, they can alter the shares. Here, she was not made a party. So that is why, unless your lordship permits or makes an observation that they must be, the Allahs of Sampadamma has to be made parties, and I will not be able to convince the trial court. That is one request to your lordship, number one. That is regarding say is concerned. Then the share will be 1/8, not 1/7. It will vary. That is one point on the legal aspect. Another aspect is this, my lord. One Dasaya, your lordship kindly see I have produced genealogical tree, page 42. ಈ appeal memo ಜೊತೆ
42 ಹೇಳಿ.
ಅದರಲ್ಲಿ ಚಿಕ್ಕಣ್ಣಮ್ಮ ಆದ್ಮೇಲೆ ಸಂಪತ್ತಮ್ಮ ಬರ್ತದಲ್ಲ, ಲಾಸ್ಟ್ ಗಾಟ್ ಇಟ್ ಲಾಸ್ಟ್ ಎರಡು ಸಂಪತ್ತಮ್ಮ ರುಕ್ಮಿಣಿ ಅಂತ ಬರ್ತದೆ ನೋಡಿ. ಈ ಸಂಪತ್ತಮ್ಮ she died and her 3 children Kumaraswamy, Mohan Kumar, Meenakshi are alive, and I have produced the address and other details of these 3 persons in the appellate court along with an IA, Xerox copies of the address proof, everything. And that is how I and in affidavit also I have stated that she was the one of the daughters, and she has left these LRs. So this may be the matter where your lordship may either decide or remand. I leave it to your lordship that aspect of the matter. Next matter, my lord, in the left, your lordship may kindly see in the genealogical tree, your lordship got Ningamma Karibasavaya anteli. Left W1 anteli. Karibasavaya alias Dasaya was taken in adoption is what the affidavit and application I filed before the RA, in the RA before the appellate court. I have stated in the affidavit that he was taken in adoption by one Kunnaya and Mallamma, and he never resided along with these persons in this family and tell you in affidavit alli. If that is the case, they get no right. Andre 1/7 share adu hortu hogutte avaradu. That is another aspect of the matter. But I did not take the defense. I did not file the written statement. That's the unfortunate thing. I do not know how I will, unless delay is condoned and appeal is admitted in RA, I will not be able to, because on merits ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ ಅವರು RA ಅಲ್ಲಿ. But delay not condoned, dismissal.
Relationship is concerned, no dispute. ಹೌದಾ?
ಹೌದು ಇದೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇಷ್ಟೇ ಇರೋದು. ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ನಾವು ಮಾಡಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ. ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಕರಿಬಸವಯ್ಯ alias ದಾಸಯ್ಯ is not no more the son of Karibasavaya alias Basavaya. ಅವರ ಅದು ಒಂದೇ ಹೆಸರಿದೆ, ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ಬಹುದು. Karibasavaya alias Dasaya alias Basavaya ಅಂತ is the father. Karibasavaya Dasaya is this one of the sons, and other group is all these defendants. So these plaintiffs are claiming only through Karibasavaya. All the plaintiffs 2 to 7, they claim one share through Karibasavaya alias Dasaya. According to me, Karibasavaya Dasaya was adopted and taken away or left the family, and he was staying with the Kunnaya and Mallanna and not with this family. That is one of the affidavit statement ಹೇಳಿದ್ದೀನಿ IA ಅಲ್ಲಿ trial ಇದು RA ಅಲ್ಲಿ. So if that is also taken up, then they may not get the right. So in the affidavit I have stated they have no right. ಈ ತರ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಅದನ್ನ ನಮಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ಲಿಲ್ಲ because the delay is not condoned. ಮೆರಿಟ್ಸ್ ಅಲ್ಲಿ ಅವರು ಏನು ಬರ್ದಿಲ್ಲ. This is the situation. ಬೇರೆ ನಮಗೆ ಅದರಲ್ಲಿ ಬೇರೆ ನನಗೆ ಹೇಳಕ್ಕೆ ಬರೋದಿಲ್ಲ. And one more thing is regarding evidence, my lord, RA ಅಲ್ಲಿ evidence was recorded and evidence was, oral statement was taken, but court says you have not produced the medical certificate regarding the illness. Affidavit ಆಗಿದೆ PW1 RW1 ಅವರದ್ದು.
ಅದು ವಿಚಾರಣೆ ಆಗಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್, ಅದಕ್ಕೆ ವಿಚಾರಣೆ ಆಗಿದೆ.
ಅದೇ I am sorry, that's why I am saying I am sorry without verifying ನಾನು ಹೇಳೋಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ. Then your lordship said that let us get the records. That's how your lordship got the records. I am sorry I made a submission without knowing, and I said I will verify the matter. That's how your lordship wanted the records. Now the evidence is of PW1 and RW1, oral evidence, no doctor certificate. So based on that, there is no condonation of delay. When the property rights are involved, I think a leniency has to be shown ಅಂತ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ. ಇಟ್ಸ್ ಫಾರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ಆರ್ ರಿಜೆಕ್ಟ್. ಅದಕ್ಕಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಆಮೇಲೆ ನಾವು FDP was filed. In the FDP, notice was served on these appellants. Then they filed the appeal RA. ಅವ್ರಿಗೆ ಅದರ ಮೊದಲು ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. That is how it has. ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳೋದು ನಾನು ಒಪ್ಪಲ್ಲ. ಯಾಕಂದ್ರೆ
What is the stage of
engage an advocate. ಗೊತ್ತಿಲ್ಲ
What
ಅಂತ
is this? What is the stage of FDP now?
FDP my lord.
Still it is
FDP ಅಲ್ಲಿ ಸ್ಟೇ ಹೇಳ್ತೀನಿ ನಾನು. FDP ಅಲ್ಲಿ ಅಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. ಇಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ RSC ಅಂತ. ಆ ತರ ಇದೆ ಅದು. ಡೇಟ್ ನನಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಡೇಟ್ ಜ್ಞಾಪಕ ಇಲ್ಲ.
FDP ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ವಾ?
ಹೌದು ಪೆಂಡಿಂಗ್ ಇದೆ.
ಆಯ್ತು. ನೋಡಿ. How do this matter is listed for admission? How do the
opportunity ಒಮ್ಮೆ ಕೊಟ್ಟರೆ ಆಗ್ಬೋದು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. It is there, well and good.
Legal right, that's all. ಮತ್ತೊಂದ್ ಸರಿ ಇನ್ನೊಂದು ರೌಂಡ್ ಆಪರ್ಚುನಿಟಿ ಕೊಡೋದು, ಸೆಟ್ ಅಸೈಡ್ ಮಾಡೋದು, ಮತ್ತೆ ಅಪೀಲ್ ಬೇಕಾಗಿಲ್ಲ. FDP ನಲ್ಲಿ that let them decide the share with regard to the ಸಂಪತ್ತಮ್ಮ
LRs. ಅವರ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ನಾನು ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
I will make that observation in the order itself.
Saying that they may be pleaded in FDP.
ಅಷ್ಟೇ ನೋಡಿ.
ಆದ್ರೆ ಶೇರ್ ವೇರಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ. And of course
1/7 ಬದಲು 1/8 ಆಗುತ್ತೆ ಅಷ್ಟೇ.
1/8 ಆಗುತ್ತೆ. And regarding that adoption, I think I may not be able to take up unless your lordship permits.
ಆಯ್ತು ನೋಡಿ. Heard the appellant counsel. This matter is listed for admission and heard the appellant counsel.
Once again, I am sorry I could not make a submission last time.
No problem. And this court also secured the records of the appellate court. And also ಎರಡು ಬಂದಿದೆ ಮೇಡಮ್, only appellate court. Appellate court. Since there was an issue with regard to the whether evidence has been recorded or not before dismissal of the appeal.
ಇಲ್ಲ ಆ ತರ ನಾವು ಅಬ್ಸರ್ವ್ ಮಾಡಿಲ್ಲ. That is not necessary. Just wanted to verify ಅಷ್ಟೇ.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು
ಅದೇನು ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ.
Evidence has been recorded or not
before dismissing the appeal on the ground of limitation. The factual matters of case of the plaintiffs before the trial court that one Kari Basavaya alias Dasaya alias Basavaya had two wives by name Ningamma and Kendamma. First wife Ningamma had a son by name Kari Basavaya alias Dasaya, who is no more. The first plaintiff is wife and plaintiff number 2 to 6 are children of said Kari Basavaya alias Dasaya.
2 to 7 my lord.
2 to 6 or 7?
7 ಅಂತ ಕಂಡಂಗ ಆಯ್ತು.
2 to 6. 7 Geeta wife of not 7.
ಸರಿ daughter ಸರಿ.
7. Plaintiffs. Children of Kari Basavaya. The second wife Kendamma had 3 children who are ಇಲ್ಲಿ ಕರಿ ಬಸವಯ್ಯ ಅಂದ್ರೆ ಇಬ್ಬರು ಇದಾರೆ, ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೋಬೇಡಿ. ಫಾದರ್ ಅನ್ನು ಕರಿ ಬಸವಯ್ಯನೇ, ಒನ್ ಆಫ್ ದಿ ಮಗನು ಕೂಡ ಕರಿ.
ಆದ್ರೆ ಅವರಿಗೆ ದಾಸಯ್ಯ ಇದೆ, ಇವರಿಗೆ ಬಸವಯ್ಯ ಇದೆ.
ದಾಸಯ್ಯ ಬಸವಯ್ಯ,
ಅವರಿಗೆ ಬಸವಯ್ಯ ಇದೆ ಅಪ್ಪನಿಗೆ, ಇವರಿಗೆ ಬಸವಯ್ಯ ಇಲ್ಲ. That is the difference.
The second wife Kendamma had 3 children who are dependent number 1 to 6. Two children properties are ancestral and joint family properties of plaintiffs and dependents. After demise of Kari Basavaya alias Dasaya alias Basavaya, the plaintiffs and dependents have been in joint possession and enjoyment of the social properties. After demise of Kari Basavaya, the husband of plaintiff number 1 and dependent number 1 were in possession and enjoyment of the social properties. The dependent number 2 to 6 being employees of government are residing in their respective places. The first defendant has got item number 1 and 2 of the social properties mutated in his name illegally in order to defraud the shares of the plaintiffs. Item number 3 and 4 are Chakram Inam properties, which are not mutated in the name of any parties. So, but the plaintiffs and defendants are in joint possession of the same. The first defendant tried to sell away the social properties. So, the plaintiffs got issued legal notice dated 31/12/2013 calling the first defendant to allot their share in the social properties. In spite of first defendant did not make any partition, then suit is filed. The defendants 1 to 6, though appeared through their counsel, have not filed any written statement. The plaintiff, in order to prove their case, examined the second plaintiff as PW1. Also examined 2 witnesses as PW2 and 3 and got marked document exhibit P1 to P10. The trial court, after considering the the oral evidence and documentary evidence placed before the court comes to the conclusion that social properties are ancestral and joint family properties of the plaintiffs and defendants, and also comes to the conclusion that plaintiffs are entitled for 1/7 share in the social properties of item number
1 to 5.
1 and 5 of the social properties. The suit is dismissed as far as item number 3 and 4 of social properties are concerned. Being agreed by the judgment and decree, the defendants have filed an appeal in RA number 18 of 2016, wherein there was a delay of 324 days in filing the appeal. The appellate court recorded the evidence of the parties with regard to the delay is concerned as PW1 and RW1. And having considered the material available on record, the first appellate court comes to the conclusion that delay has not been properly explained. Coming to the conclusion that appellants were very well aware about the trial of case before the trial court. Despite having the knowledge of the trial and disposal of OS 56 of 2014, the appellants have not come forward to contest the matter. It is also taken note of that FDP number 1 of 2016 is also filed, and commissioner report is already received. Only in order to avoid legitimate share of plaintiffs and to harass them, the present appeal is filed. And also taken note of the fact that they did not file any written statement in spite of they have appeared through their counsel. And the said fact is also not disputed. And the judgment was also pronounced on 4/8/2015. And appeal was filed on 27/7/2016. About delay of 358 days, and the same has not been explained. And appellate court also taking note of the evidence available on record. The paragraph number 21. Taken note of PW1 is an educated person and he is also a central government employee. Taken note of the reasons given in the cross-examination, that he had no problem to provide documents to the advocate. And the said admission is also taken note of on paragraph number 24. Taken note that copying application was filed on 7/4/2016. Copy was ready on 23/4/2016. Same was taken on 10/6/2016, and even taking the copy of the order also there was a delay, and hence dismissed the appeal on the ground of delay. Hence the second appeal is filed before this court. The counsel appearing for the appellant vehemently contend that the plaintiffs, while filing the suit, have left out one Srimati Sampathamma, who is the daughter of late Karibasavaya, and she is also
LR's, my lord. Sampathamma was dead by then.
Adene. Yen madam?
The name of
Srimati Sampathamma, who is the daughter of late Karibasavaya, and she is also having equal share. And though she is no more, her sons are entitled for share. And it varies the shares also. The council also submits that the court below committed an error in granting the share without adding the other people here, Srimati Sampathamma. Council also would submit that the first appellate court also committed an error in rejecting IA number 1, not appreciating the reasons assigned in the application for condonation of delay. Hence, substantive question of law arises for this court that first appellate court committed an error in not appreciating the evidence on IA1 to prove the facts and circumstances, wherein also sufficient cause was shown. The same was not considered. And even calculating the shares of the parties also, Kiranias and Sampathamma were not included, and our legal heirs are also not, Sampathamma, legal heirs of Sampathamma were not included. Hence, it requires interference. Having heard the counsel appearing for the appellant, and also the claim of the plaintiff, where they contend that property belongs to the joint family. And Kari Basavaya alias Dasaya and Basavaya having 2 wives. One is Ningamma and another is Kendamma. And plaintiffs are the wife and children of the first son, of the son of first wife, Ningamma. And also not in dispute that defendants are also representing the second wife, are all these children of second wife, Srimati Kendamma. And also no dispute with regard to the property belongs to the joint family. The very contention of the counsel appearing for the appellant that the appellants could not file written statement before the trial court. And in the appellate court, they have challenged the very decree. And they have not taken any defense in the trial court that legal heirs of Sampathamma were not arrayed as parties to the proceedings. And the trial court granted decree considering the evidence of the plaintiffs and also considering the documentary evidence. The appellate court also considering the evidence which has led to condone the delay, taken note of the PW1 who has been examined as witness in the appellate court with regard to the delays concerned, comes to the conclusion that he is an educated person and also working in the central government. And also not condone the delay of 358 days, which has not been properly explained, and no documents are placed before the court, even for medical grounds also. Taken note of the cross-examination of PW1 where he has admitted that he has not provided the document and there was no any difficulty to provide the documents to the advocate. The only contention that his brother had taken treatment for 2 to 3 months as an outpatient, not as an inpatient, and medical records also not placed before the court. It is also not in dispute that the properties belongs to the joint family, and the very contention of the appellant counsel that the LRs of Sampathamma, who is also the daughter of the second wife of Kari Basavaya. 1 second. Second daughter of
Second wife, daughter of Kendamma.
Daughter of Kendamma was not arrayed as party. The same cannot be a ground in second appeal. The parties can urge the said ground before the final degree proceedings also, since final degree proceedings is not yet decided. The apex court also in the Vinit Sharma case held that even with regard to the modification of share, any alteration of share, and the same can be urged in the FDP, final degree proceedings. And hence the first contention cannot be accepted. The second contention of the appellant counsel that the Kari Basavaya, that is the father of the plaintiff, was taken in adoption. And to that effect also no written statement was filed and also no such defense was taken before the trial court. And that is also not the ground in the second appeal. The only substantive question of law is raised with regard to the not giving an opportunity. And also not arraying the LRs of Srimati Sampathamma. And for the first time, the said ground is also raised.
Yeah, that is mentioned in Arya, my lord. Arya ground number 9 is that.
Array 9 al ಮಾಡಿದಿರಿ ಬಟ್ ಇಲ್ಲಿ ನೀವೇನು ಹೇಳಿಲ್ಲ ನಿಮ್ ಸಬ್ಸ್ಟ್ಯಾಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ದಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಅದನ್ನ ಅಫ್ಕೋರ್ಸ್ ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನನಗೆ ಪ್ರಾಬ್ಲಮ್. ಅದು 9 ನೋಡಿ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದೀವಿ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ. ಪೇಪರ್
ಏನಾಯ್ತು ಮೇಡಮ್? For the first time, the said ground was urged in the first appellate court without filing any written statement before the trial court.
Yes, my lord.
Having taken note of the said fact into consideration, and the same cannot be a ground in a second appeal to consider the same. Admittedly, no dispute with relationship between the parties and also no dispute with regard to the property which is involved in the suit is also a joint family property, and it only varies the share if the LRs of the Sampathamma are added as parties in the final decree proceedings, and parties can seek for an implement of the legal heirs of Sampathamma before the final decree proceedings, and hence I do not find any ground to admit and frame any substantive question of law in second appeal. You have the discussions made up. I pass the file on order. Appeal is dismissed.
And permitted to implement that also final order.
Permitted and can apply yes.
Apply can apply.
Observed the Vineet Sharma case. Otherly specific final decree madvaga note anta ಮಾಡಿ observe ಮಾಡಿದೀನಿ. And hence
apply.
And another note is that non-joint of one on the purchase of the suit item number 3. The three circumstances that I put appellate court mainly the findings where honorable appellate court did not accept the findings of the trial court, and it is held that the relationship has been proved. Furthermore, appellate court without answering any of the issues determined the point for the determination in page number 39, whether this suit is barred by limitation, whether the plaintiff proved that item number 1 of crucial property had been purchased out of the joint family case, whether the judgment and decree of the trial court is apparent illegal, therefore this illegal submission for the separate court find that the relationship has been established. So going to the state of the case, it has defined the matter because specifically from that plaintiff established the relationship as per the criminal record. And furthermore, non-joint of the party is concerned, it is the settled position of the court that no suit for partition non-joint of the parties, that is the purchasers. The proper parties are the common court bearers who have to be made as a party, and in this regard also I relied upon the judgment. In this regard also the first appellate court when accepted my arguments did not raise any finding. Furthermore, appellate court
Appellate court comes to the conclusion that suit is barred by limitation. First point, affirmative. Other issues are negative.
The finding of the trial is that the party is
Already.
entitled for share, but he did not claim the partition right time. And
Where is that finding?
Page number 38, paragraph 14. Fact of the present case is examined in the light of judgment as expected. This case, the court cannot appreciate the case on the ground that it is read for non-gender of necessary party, and the father of the plaintiff was not in possession of property. This court has declined to accept petition on the ground that item number 1 of the property had been purchased by 4 sons of the Narsimhaya long back in the year 1957 as per equity 15, and after lapse of 20 years, the plaintiff have come up with the case that the said property had been purchased out of the joint family nucleus. The father of the plaintiff never challenged the sale deed on the ground that item number 1 of the property was purchased out of the joint family nucleus. Apart from that, in respect of item number 2 to 4 of the property, same was acquired by the 4 by release deeds also. By virtue of release deed, 4 brothers have divided the property and they have sold the same in favor of subsequent purchaser by virtue of the sale deeds as discussed above. The father of the plaintiff and defendant plaintiff had seen all these developments and they had issued notice calling upon the defendants to give their legitimate share. When it was refused, either the plaintiff or their father have failed to take action and sought for partition by filing this suit. Therefore, on the ground of delay and access on the part of the plaintiff and his father to seek partition, made this court to refuse the relief. Therefore, the decisions referred above cannot be made applicable to the fact of the present case. With regard to retaining of the point of appellate court on the point that appellate court also answer all the evidence to be communicated and record. Also, party cannot be discussed. It also yeah, 2001 Supreme Court 217. Sukar and others were Sangam and others para number 5 and related.
Sale ಯಾವ ಇಯರ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿರೋದು?
ಎಲ್ಲ 2006 ಕೇಸ್ ಹಾಕಿದೆ 2007 4, 5, 6 ಆಗಿದೆ. Purchasers also made as a party to the suit. The party has not been made as a party, that is the pending of the trial court for non-necessary party concerned.
But it's his right will affect. Why you have not made him as party to the proceeding? Satish ಅಲ್ಲ ಇನ್ನೊಬ್ಬ ಯಾರು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್ ನ ನೀವು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ಡಿಸಿಷನ್ ಇರ್ಲಿ, ಬಟ್ ಇಟ್ ಅಫೆಕ್ಟ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದಿ ಪರ್ಚೇಸರ್ ಅಲ್ಲ. ಫಾರ್ಮಲ್ ಅಂತ ಹೆಂಗಾಗ್ತದೆ?
Cannot be made as a party to the suit. They will be made as a party to the FTP because they purchased the share of the vendors. The binding of the court at the division bench of the court. And in this regard also I read many judgments before the first appellate court. And first appellate court.
ಏನು ಈ ಚಂದ್ರಶೇಖರ್ ಸೋಮಶೇಖರ್ children of Narayanappa, property belongs to originally
belongs to the father of this Naranappa, item number 1. They themselves purchased this property in the year 1957. Paragraph 32 may kindly be
ನಾರಾಯಣಪ್ಪನ ಮಕ್ಕಳು ಇವರಿಬ್ರು ಹೌದಾ? ಪ್ಲೈಂಟಿಫ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ಸ್
to 8 are the children of other court brothers of Narayanappa. The 5th share has been sought for the trial court. Father of Narayanappa is having the 4 sons, including him. They purchased the property item number 1 in the year 1957. And the first finding of the honorable trial court.
Why the trial court comes to the conclusion that relationship is not prudent?
That is genealogical tree and other that TPA related by the plaintiff is not forthcoming about the relationship. It is not the proper document Aadhaar card and other documents cleared by me before the trial court is not acceptable. That is the finding given by the honorable trial court. I will read out.
Who is the propositors of the family?
Four children of the
Propositors of the family. Kodda Narasimhayya. He was having how many children? Narayanappa and
Narasimhayya,
Chikka Narasimhayya.
by Narayanappa, Chikka Narasimhayya, Nagappa and Krishna.
Papa and Krishnappa.
They purchased
Plaintiffs are the children of Narayanappa. Howda? Chikka Narasimhayya ಎಷ್ಟು ಜನ ಮಕ್ಕಳು?
Narasimhayya, this binding sale deed dated 19/5/1957.
ಚಿಕ್ಕ ನರಸಿಂಹಯ್ಯನ್ಗೆ ಎಷ್ಟು ಜನ ರೀ ಮಕ್ಕಳು? 2, 3, 4.
Number 4, 5, 6.
Number?
Number 4, 5, 6.
4, 5, 6. ಹೌದಾ? ನಾಗಪ್ಪನ್ಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? ನಾರಾಯಣಪ್ಪನ್ಗೆ ಆಯ್ತು, ಪ್ಲೇಂಟಿಫ್ಸ್ ಆಯ್ತು. ನಾಗಪ್ಪ?
Number 10, 11, 13, 14. 8 to 14.
ಕೃಷ್ಣಪ್ಪನ್ಗೆ?
15. Number 15.
ಒಬ್ಬನೇನಾ? Subsequent purchasers ಯಾರು? Different number?
Other dependent
16 to 20 are?
20.
16 to 20 are purchasers. ಇವ್ರಿಗೆ ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ದು?
4 ಜನ ಮಕ್ಕಳು ಮೊಮ್ಮಕ್ಕಳು ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದ್ರು.
Already there was a partition.
1980 ನಲ್ಲಿ ರಿಲೀಸ್ ಡೇಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. Children of the 4 brothers.
4 brothers among themselves have got it.
Release date ಮಾಡ್ಕೊಂಡು.
ಹಾ.
ಅದು ಬೇಸ್ ಮೇಲೆ 4.6 ಅಲ್ಲಿ.
Whether these the plaintiffs are also parties to the release deed? Release deed? ಇಲ್ಲ. ಮತ್ತೆ?
The reason
ಹಾ.
Particular court find that these plaintiffs are also having their share, but they did not file the case within the time. Because the father has given the notice in the year 1979. Admission given
79 ಅಲ್ಲೇ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಫಾದರ್.
with regard your honor,
Narayanappa himself has given notice to the other defendants, other brothers.
Is the binding record by the corporate. And in this regard, your honor, praying this on to court that partition unless the actual partition is taken care, root of the partition cannot be of dictation. The submission reports honorable court. And the honorable first appellate court did not consider this argument and also not given opportunity to address the points raised by the first appellate court.
Whether any of the properties are given to the share of this Narayanappa? ಇಲ್ವೇ ಇಲ್ಲ.
Zero. With regard
ದೊಡ್ಡ ನರಸಿಂಹಯ್ಯನ್ಗೆ ಹೇಗೆ ಬಂತು ಈ ಪ್ರಾಪರ್ಟಿ?
57.
He had purchased the property in the year 1957.
That is to the ancestral income only another first appellate court finding. ಅದರಿಂದ ಇವ್ರಿಗೆ ರೈಟ್ಸ್ ಇದೆ, ಬಟ್ ವಿತಿನ್ ಟೈಮ್ ಅಲ್ಲಿ ಫಾದರ್ ರೂಟ್ ಹಾಕ್ಲಿಲ್ಲ, ಇವರು ಹಾಕ್ಲಿಲ್ಲ. 50 years
79 ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ರಲ್ಲ, ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ಟವ್ರ?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ, ಯಾವ್ದು ಆಂಧ್ರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಆ ರೀತಿ ಅಡ್ಮಿಷನ್ ಇದೆ ಅಂತ
ಬಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ತಕ್ಷಣ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅರೈಸ್ ಆಗ್ತದಲ್ಲ. ಆಯ್ತು, 79 ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟರು, 1989 ಅಲ್ಲಿ ಅಮಾಂಗ್ ದಮ್ registered document. Then you would have questioned the same in the year 1980 itself.
Get to observe that by virtue of exhibit D 14, release date dated 11/10/1880. Even date and their sons have told the property. So release date ಮಾಡ್ಕೊಂಡಿತ್ತು. ಅದನ್ನ told as per exhibit D 17, certified copy of this LD dated 3/1/2007. Bearing 1D manual FC proposed also.
Now, where is the finding in the appellate court that with regard to the relationship between the parties is concerned?
Para 30 maintained.
Para 30.
That is number 49. Page 49. As rightly pointed out by learned counsel for the plaintiff, ration card at exhibit B31, voter's ID, PAN card, Aadhaar card clearly established that the plaintiff or the Narayanappa. Apart from that, even on careful perusal of entire cross-examination directed to PW1, it is nowhere specifically denied that they are not the sons of this Narayanappa. The trial court has committed error in appreciating exhibit B15, power of attorney, and also committed further error in appreciating exhibit B16, genealogical tree, by stating that these documents have been created for the purpose of the truth. It is significant to observe that as per the admitted fact, the father of the plaintiff, Narayanappa, abandoned the village and settled in Andhra Pradesh long ago. Under such circumstances, it is difficult for the plaintiff to establish that they are the sons of Narayanappa, apart from producing the document, that is ration card, voter ID. Therefore, the finding of the trial court that plaintiffs are not the sons of Narayanappa cannot be sustained. But however, merely proving the relationship by the plaintiff with this Narayanappa itself doesn't give them indispensable right to life share in the scheduled properties. Let's take that scheduled properties are the unscheduled properties. In this regard, Your Honor, the honorable right separate court observed that plaintiff
Notice. Issue notice.
Became the injunction and mandatory. The trial court
Injunction granted, mandatory injunction is rejected.
was as of the sought for declaration of not maintainable. But the lower appellate court reasoning kindly turn to page number 13 of our judgment in RA.
Not easement right, madam. Prayer you go to see. 72. Restraining the defendant, their agents, servants, and defendant from interfering with plaintiff's peaceful position and enjoyment of lane, and to restrain them from closing or in way, blocking the place shown as FQHW in this case. Yes.
Attention is, watchers may kindly turn to page number 13 of RA judgment. Page number 13. Case of the plaintiff that in front of his house, there is a lane which measures east to west 10 and north to south 100. Is the only way for the plaintiff.
You are reading at the page number
13. Reasoning.
13 of the appellate court.
11 of the appellate.
11 of the appellate court.
It is a case house, there is a lane which measures east to west 10 feet and north to south 100 feet.
Necessarily attempt.
Defendant submit that the plaintiff has no right for the sale. The house of plaintiff is having its door to its northern side, and he has been using the road which is situated on the northern side of his house. Plus, the rest of the in page number 13.
Hmm.
Specific.
Hmm.
That how he has got right of way over the suit schedule property.
Hmm.
Their respective homes. The defendant number 2 has admitted the government has put up drain and pipe for the supply of water in the site. Therefore, now the only question that arises consideration of this court is whether the plaintiffs have proved for the learned trial court that they have got right to use this suit schedule lane or not. Thereafter, para number 8, Government Counsel for Appellant has argued that the plaintiff has not taken contention of judgment. No evidence is produced with regard to the interference of the defendants. The trial court has not framed issue in respect to therefore, the trial court has erred in this.
That is argument. Reasons kogi. Reasons kogi. Hmm.
That the plaintiffs have how these two documents. It needs to be noted that nothing is mentioned in these documents about the right of the plaintiffs over the suit schedule property or existence of the suit schedule property towards southern side of the house of plaintiff has contended with the plain and rough sketch next to the plain. On the other hand, the defendants have produced 5 assessment registered. In those documents, there is no averments about the lane, alleged lane. Must be noted here that the defendant have admitted the existence of lane, but the dispute is with respect to the right of plaintiffs over the said lane. Other Milords, pertinent to the plaintiffs have not pleaded relations and defendants. But in cross-examination of PW1 has given details about the relationship of plaintiffs and defendants. PW1 is a cross-examination stated that his father of plaintiff number 1 is the brother of father of defendant number 2. Others are existing. It's noted that the defendants have not denied this. Chief examination PW, but examination nothing is released from the mouth regarding the right of the claim. It is specifically denied position of the learning council that his father's brother has left the said claim. The cross-examination PW2 and we have admitted suggestions of the learning council that there is a road towards north of the house of the plaintiff. PW1 has also admitted this fact. In fact, he has admitted that on the northern side to his house, there is a road for him available. And but he has denied that the door of his house towards house is in north. PW1 has specifically denied suggestion of the council that he is using the road existing on the northern side of his house. Only on the ground that PW1 to 3 admitted there exists a road on northern side. It cannot be said they have no right to use this schedule lane. Admittedly, the father of plaintiff number 1 and father of defendants are brother. They have partitioned the family property. When they have partitioned the family property, there should be a right to use the lane by all members of the family to reach the main road. And on this basis, it is well that it can be presumed that plaintiff, his father, defendants have been using the lane from the date of partition till the till partition of the family property. No such partition or the right to use the lane has been pleaded in the plain by the plaintiff. This presumption looks
Madam, in evidence you have admitted.
said. Southern side.
No. DW3 in his affidavit deposed that said lane has been using all the people who are residing in the locality. This deposition of DW3 shows that plaintiff is also using the said lane because the plaintiff is also residing in the same locality. It is pertinent to note that in his class examination, DW3 has clearly admitted that plaintiffs have no other way to reach the road which is existing towards northern side. He further admitted that public also using the said lane, public also taking water from that place. So DW3 also admitted that said lane has been existing since 100 years. Thus, though the defendants have denied the case of the plaintiffs in the class examination, they have admitted the existing of the social property and also usage of the said lane by the plaintiff. Though defendants have contended that there is a road on the northern side of the plaintiff, no evidence is produced in this regard. Though the plaintiffs have not produced any documentary evidence regarding their right over the social property, the oral evidence of both parties prove that plaintiffs and defendants are cousin brothers and their fathers have partitioned the family properties as there is no any other road for the plaintiff. To reach the main road, the plaintiffs have got right to use the suit scheduled lane. Where is that admission?
Evidence of PW1. ಉತ್ತರ ವಿಭಾಗವಾದಾಗ ಉತ್ತರಾಂಶವು ನನ್ನ ತಂದೆಗೆ ದಕ್ಷಿಣಾಂಶವು ಚಿಕ್ಕಮಾದಯ್ಯನವರಿಗೆ ಬಂದಿರುತ್ತದೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ತಂದೆ ಸದರಿ ಚಿಕ್ಕಮಾದಯ್ಯ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಮತ್ತು ನಮ್ಮ ಮನೆಯಿಂದ ಉತ್ತರಕ್ಕೆ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ ಹೋಗುವ ಒಂದು ರಸ್ತೆ ಇದೆ. ನಮ್ಮ ಮನೆಯ ಬಾಗಿಲು
ಮೇಡಮ್, ಈ ರೋಡ್ಗೆ ಗವರ್ಮೆಂಟ್ ನವರೆಲ್ಲ ರೋಡ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ದಾರೆ, ಡ್ರೈನೇಜ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ನೀವು why you are obstructing the plaintiff? That is an admission by DW1 also. And why you are troubling the plaintiff? He is also your cousin. Whatever it may be, madam, that lane also, even government also formed a drain also. ಆಯ್ತು plaintiff ನಡೆದಾಡಿದ್ರೆ ಏನಾಗಲ್ಲ ಅಲ್ಲಿ. ಏನ್ obstruction? You are causing obstruction ಅಂತ, that is his case. Read paragraph 20 and 21, madam. Defendant number 1. In his class examination, DW1 has admitted the existence of lane and its measurement. He stated that the said lane is existing since 15 years and denied the suggestion that it has been existing since 100 years. But the DW3 admits that since it is in existence from last 100 years. DW1 has admitted that said lane is abutting to the main road, and when he attempted to close the said road, a criminal case has been lodged against him. Nimmone admit ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ ನೋಡಿ ಅವನು. He started to close that road. The admission shows that the defendants and plaintiff have been using the said lane to reach the main road, and DW1 has attempted to close the said lane. DW1 has also admitted that government has formed drainage and put up water pipes. ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಆ ರೋಡ್ ಅಲ್ಲಿ. Why you are troubling?
Southern side has been allotted defendant's predecessor, and he has admitted in the cross examination. The admission of the PW1 had not been considered by the courts below. ನಮ್ಮ ಮನೆ ಉತ್ತರ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿ ಇದೆ ಎಂದರೆ ಸರಿ. He admitted there is a road on the northern side, and ಮಹದೇವಯ್ಯ ಎಂಬುವವರು ಮೇಲೆ ಹೇಳಿ he admits all the partition and that southern portion was allotted to Chikkamadayya.
Madam, they are the cousins, madam. ಎಲ್ಲ ಒಂದೇ ಫ್ಯಾಮಿಲಿಗೆ ಸೇರಿದವರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ಪ್ರಾಪರ್ಟಿ. Why you are causing obstruction? ಆಯ್ತು, ನಿಮ್ಮೊಬ್ಬರಿಗೆ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಯೂಸೇಜ್ ಅನ್ನೋದಕ್ಕೆ ದಾಖಲೆ ಇದೆಯಾ? ನಿಮ್ಗಿದೆಯಾ ದಾಖಲೆ? Exclusive use of defendants ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾರು ಇದೆಯಾ? You are asking documents of plaintiff that can be used on. Whether you are having any document to exclusive usage of that lane. Madam, ego ಎಲ್ಲ ಬಿಡ್ಬೇಕು madam first. Ego ಬಿಡ್ಬೇಕು first. Yeah, he is also a part of your family. Why you are causing obstructions to enter into the? ಆಯ್ತು ಮೇಡಮ್, ಇದು ಜಾಗ ಸರ್ಕಾರ ಈಗ ಎಲ್ಲ ಲೇನು ಎಲ್ಲ ಮಾಡಿ ಡ್ರೈನ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿದೆ, ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ? ಆಯ್ತು, ನಿಮಗೆ ಸೇರಿದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಇದೆಯಾ? ನಿಮಗೆ ಈ ರಾಸ್ತೆ ಸೇರಿದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಅಂತ ಯಾರು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ? ಏನಂತ? ಉತ್ತರಾಂಶ ದಕ್ಷಿಣಾಂಶ ಅದು ಶೇರ್ ಬಂದಿದ್ದ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾನೆ ಅಷ್ಟೇನೆ. ಪ್ರಾಪರ್ಟಿ ಎವಿಡೆನ್ಸ್ ಕಾಪಿ ಇದೆಯಾ? ಪ್ಲೈಂಟಿಫ್ PW1 ಕೊಡಿ. ಏನಾರು ಅಡ್ಮಿಷನ್ ಇದೆಯಾ? ಅದರ್ ದನ್ ದಿಸ್ ಲೇನ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಅನದರ್ ಲೇನ್ ಆಲ್ಸೋ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ? ಕೊಡಿ, ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ಕೊಡಿ ನೋಡ್. ಹೋಗರಂಗಾತಿರಲ್ರಿ ರಸ್ತೆನ? ಮತ್ತೆ ಕೊಡಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ, PW1 ಎವಿಡೆನ್ಸ್ ಕೊಡಿ ನೋಡ್ ಹೋಗ್ಲಿ. ಅದೇನ್ ಅಡ್ಮಿಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ನೋಡೋಣ. ನಿಮ್ ಜೊತೆ ಅವನು ಓಡಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ನಿಮ್ಗೆ? ಆಯ್ತು, ವಿಭಾಗವಾದಾಗ ಉತ್ತರಾಂಶವು ನನ್ನ ತಂದೆಗೂ ದಕ್ಷಿಣಾಂಶವು ಚಿಕ್ಕಮಾದಯ್ಯನವರೆಗೂ ಬಂದಿರುತ್ತದೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ತಂದೆ ಸದರಿ ಚಿಕ್ಕಮಾದಯ್ಯ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ತಂದೆಯ ದಕ್ಷಿಣಾಂಶವನ್ನು ಚಿಕ್ಕಮಾದಯ್ಯನವರು ಅನುಭವಿಸಿ ಬಂದರು. ನಮ್ಮ ಮನೆಯಿಂದ ಉತ್ತರಕ್ಕೆ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ ಹೋಗುವ ಒಂದು ರಸ್ತೆ ಇದೆ. ಆಯ್ತು, ಪೂರ್ವ ಇಲ್ಲಿಂದ ಉತ್ತರಕ್ಕೆ ಆಯ್ತು. ನಮ್ಮ ಮನೆಯ ಬಾಗಿಲು ಉತ್ತರಕ್ಕೆ, ಆ ರಸ್ತೆಗೆ ಅಭಿಮುಖವಾಗಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಡಿಲೇ ಮಾಡಿದಾನಲ್ಲ ಅದನ್ನ. ಮುಂದಿಂದ ನೋಡ್ಬೇಕು, ಬರೀ ಅದ್ ಮಾತ್ರ ಅಡ್ಮಿಟ್ ಮಾಡೋದಲ್ಲ. ನಾನು ಉತ್ತರದ ಕಡೆಯ ಬಾಗಿಲಿನ ಮೂಲಕ ಉತ್ತರದ ರಸ್ತೆಯಲ್ಲಿ ಓಡಾಡುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಮನೆ ಉತ್ತರದ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿಯೇ ಇದೆ ಎಂದರೆ ಸರಿ. ಮಹಾದೇವಯ್ಯ ಎಂಬುವರು ಮೇಲೆ ಹೇಳಿದ ಚಿಕ್ಕಮಾದಯ್ಯನವರ ಮಗ ಚಿಕ್ಕಮಾದಯ್ಯನವರ ಭಾಗಕ್ಕೆ ಬಂದ ಹಳೆ ಮುರುಕಲು ಮನೆ ಹಾಗೆಯೇ ಇದೆ. ಈ ಮನೆಯಲ್ಲಿ ಮಹಾದೇವನವರು ವಾಸವಾಗಿದ್ದಾರೆ. ಮನೆಯಿಂದ ಉತ್ತರಕ್ಕೆ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ ಹೋಗುವ ಒಂದು ರಸ್ತೆ ಇದೆ. ನಮ್ಮ ಮನೆಯ ಬಾಗಿಲು ಉತ್ತರಕ್ಕೆ, ಆ ರಸ್ತೆಗೆ ಅಭಿಮುಖವಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅವನಿಗೆ ರೋಡಿಗೆ ಇಲ್ವಲ್ಲ ಅವನ. ಏನಂತ? ನಾನು ಉತ್ತರದ ಕಡೆಯ ಬಾಗಿಲಿನ ಮೂಲಕ ಉತ್ತರದ ರಸ್ತೆಯಲ್ಲಿ ಓಡಾಡುತ್ತಿದ್ದೇನೆ. ನಿಮ್ಗೆ ಸರ್ಕಾರ ಸವಲತ್ತೆಲ್ಲ ಬೇಕು, ಆಮೇಲೆ ಮಾತ್ರ ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ಇಂಡಿವಿಜುವಲ್ ರೈಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಟ್ ಲೇನ್. ರೋಡ್ ಏನೋ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಎಲ್ಲ ಯಾವ ಸರ್ಕಾರಿ ಕಚೇರಿಗಳಲ್ಲಿ ಯಾವುದೇ ದಾಖಲಾತಿಗಳಿಲ್ಲ ಎಂದರೆ ಸರಿ. ದಾವ ಬಲ್ಲಿಯಲ್ಲಿ ಒಂದನೇ ಪ್ರತಿವಾಸ ಮನೆ ಅಳತೆಯನ್ನು ಮಾಡಿಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ವಾಸ ಇವರು ಮನೆ ಖಾತೆ ಉತ್ತಮವಾದವೇ ನಾರಾಯಣ ವರ್ಗಾವಣೆ ಆಗಿದೆ.
There is a road on the northern side.
ಉತ್ತರಕ್ಕೆ ರೋಡ್ ಇದೆ ಅಂತ, ಬಟ್ ಅವನ ಮನೆ ಬಾಗ್ಲು ಯಾವ ಕಡೆಗಿದೆ ಮೇಡಮ್?
North side.
ಇದೆ ಅಂತ ಎಲ್ಲಿದೆ ದಾಖಲೆ? ಎಲ್ಲಿದೆ? ಉತ್ತರಕ್ಕೆ ರಸ್ತೆ ಇದೆ ಎಂದರೆ ಸರಿ ಅಂತಿದೆ ಅಲ್ವಾ? ಮನೆಯ ಉತ್ತರಕ್ಕೆ ಅವನ ಮನೆ ಬಾಗ್ಲು ಯಾವ ಕಡೆಗಿದೆ? ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿ ಆನ್ಸರ್ ಇಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿಸಿದಿರಿ? ಆ ರೋಡ್ ಇದೆ ಅಂತಾನಲ್ಲ, ಆ ರೋಡಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅವನಿಗೆ ಅಕ್ಸೆಸ್ ಇದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಡ್ಮಿಷನ್? ನಾನು ಉತ್ತರದ ಕಡೆಯ ಬಾಗಿಲಿನ ಮೂಲಕ ಉತ್ತರದ ರಸ್ತೆಯಲ್ಲಿ ಓಡಾಡುತ್ತಿದ್ದರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಮನೆ ಉತ್ತರದ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿ ಇದೆ ಎಂದರೆ ಸರಿ. ಮಹಾದೇವ ಎಂಬವನು ಮೇಲೆ ಹೇಳಿದ ಚಿಕ್ಕಮಾದೇವನವರ ಮಗ ಚಿಕ್ಕಮಾದೇವನವರ ಹಾಗೆಯೇ ಇದೆ. ಆಯ್ತು ಅವರು ಬರ್ಲಿ ನೋಡಿ. ಇಶ್ಯೂ ನೋಟಿಸ್. So respondent counsel takes time on the ground that he could not able to secure the documents. And he was served with copy of the appeal memo last week. And hence this matter on the other on date kodi madam. 24/2. K.R. Lingraj. ಏನ ಏಕೆ ಡಿಸ್ಮಿಸ್ಡ್ ವಿತ್ ಕಾಸ್ಟ್ ಆಫ್ ₹3,000 ಹೇಳಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಕೊಟ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಡಿಮಾಂಡ್ ಶಾರ್ಟ್ ಅಕಾಮಡೇಷನ್. List this matter on 9/2/20 for admission along with IS also. In the meanwhile, the registry is directed to secure the trial court record as well as the first appellate court records. Records ಕೂಡ ತರಿಸಿದೀವಿ. ಮತ್ತೆ ಇನ್ನೇನು ಬಂದಿದೆಯಾ? ಆಯ್ತು. ಲಿಸ್ಟ್ the appellant counsel 6 times list this matter on 17/2 ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಯಾಕೆ ನಮ್ಮ ಬೆಂಚ್ ಬೇಡ ಅಂತಾನ ಮತ್ತೆ ಅದಕ್ಕೇನು ಆಯ್ತು ಅವೆಲ್ಲ ಬೇಡ. ಕೌನ್ಸಿಲ್ ಒಂದ್ ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, ಓದ್ಕೊಂಡು ಬನ್ನಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸಿದೀವಿ. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್, TCR. ಹೌದು, ನಾನು ರೆಕಾರ್ಡ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅಂದ್ರೆ ಗಾನ್ ಥ್ರೂ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ. ಏನ್ ಡಿಸ್ಮಿಸಲ್ ಇರ್ಬೇಕು ನೋಡಿ. ಗೊತ್ತಾಯಿಲ್ಲ ಕೌನ್ಸಿಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಡಿಸ್ಮಿಸಲ್. ನಾನು ಓನರ್ಸ್ ಪ್ಲೇಂಟಿಫ್ ಅಂಡ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. The appellant counsel is absent. And this court wide order dated 24/1/23 taken note of that counsel was absent on 13/12/22. However, one more opportunity is given to appear on 24/1/23. And on 24/1/23 also no representation. And also made an observation that the appellant is not diligent in pursuing the matter. However, in the ends of justice, one more opportunity is given to the learned counsel for the appellant to proceed with the matter. And also made it clear that if the learned counsel for the appellant doesn't appear on the next date of hearing, the appeal will be dismissed for non-prosecution. Today also no representation, and hence it is clear that the appellant is not interested in pursuing the matter, and in view of the preemptive order dated 24/1/23, the appeal is dismissed for non-prosecution. Yes. ಯಾರು ಅದರ್ ಸೈಡ್ ಆಫ್ ಮೇಡಮ್ ಮಧುಸೂದನ್ ರಾವ್ ಇದಾರ? ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರು ನೋಡಿ. ಲೆಟ್ ಅದರ್ ಸೈಡ್ ಲಾಯರ್ ಬರ್ಲಿ, ಎದುರುಗಡೆ ಲಾಯರ್ ಬರ್ಲಿ, ಹಿಂದೆ ಬಂದಿಲ್ಲ ಬರ್ಲಿ ಅಂತ ಇಟ್ಟಿದ್ದೀನಿ. ಆಗ್ಬೋದಾ? ಕಳಿಸರಿ ನೀವು ಬರ್ಲಿಲ್ಲ, 2 ಸರಿ ನೀವೇ ಬರ್ಲಿಲ್ಲ. ಹೌದಾ? 2018. The party in person is present. Respondent counsel is absent. The appellant, the party in person seeks time. List this matter on 24/2. It is not madam. 24/2. ಯಾಕೆಂದ್ರೆ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಆದ್ರಿಂದ ಡೇಟ್ ಕೊಡ್ಬೇಕು 24/2. Yes. CS ವೆಂಕಟ ಸುಬ್ಬರಾವ್ ಗಂಗಾಧರಪ್ಪ. Say by D1 and D2 null and void. Execute sale deed confirmed. Ilva, pass over. One-fifth share was granted. Item number? Your appeal is also allowed and modified. Howda? D6 as a bona fide purchaser anta madidare. He has purchased the property. Howda? Except item number 6 in baki urleಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. 217. Self acquired property in ತೋರ್ಸಕ್ಕೆ ಏನು ಕೊಟ್ಟಿದ್ದೀರಿ? That is your defense. ಏನಂತ? ಆಯ್ತು. ಪ್ಲೇಂಟಿವ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದಾರಾ? ಮತ್ತೆ ಯಾವಾಗ ಸೇಲ್ ಡೀಡ್ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು? ಐಟಮ್ ನಂಬರ್ 217. ಯಾರು ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಇದಾರೇನ್ರಿ? ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ, ಅವರು ಬರ್ಲಿ. ಎಲ್ಲಿದ್ದಾರೆ? ಬಂದ್ರಾ? Now your grievance is only ಆಯ್ತ್ರಿ. ನೀವೇನ್ ಸೆಲ್ಫ್ ಅಕ್ವರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ತೋರ್ಸಕ್ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಕೇಳ. ಆಯ್ತು. Defendant number 5 proves that defendant number 1 has alienated the suitable property item number 6 in his favor of legal necessity of his client family. ಆಯ್ತು. whether plaintiff is bad for ನಿಮ್ದು ಎಲ್ಲಿದೆ ಸೆಲ್ಫ್ ಅಕ್ವರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ? ನಿಮ್ದು ಎಲ್ಲಿದೆ ಡಿಫೆನ್ಸ್? ಇದೆಯಾ ಇಶ್ಯೂಸ್? ಏನು ಇಶ್ಯೂ ಇದ್ದಂಗಿಲ್ಲ? ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ಸ್ಪೆಸಿಫಿಕ್ ಡಿಫೆನ್ಸ್ ದಟ್ ಇಟ್ ಇಸ್ ಎ ಸೆಲ್ಫ್ ಅಕ್ವರ್ಡ್ ಪ್ರಾಪರ್ಟಿ. ಹೇಳಿದರು. ಆಯ್ತು. ಹಾ 64. 65. ಹೌದು. ಆಯ್ತು. ಹೌದು. ಅದೇನೋ ಅಮೆಂಡ್ ಆದಂಗಿದೆ 2 acres. He is the manager of the family. Hmm. 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 Pleading. Hmm. 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 By his gaining. Hmm. Yeah, he is the karta of the family. Or admit ಮಾಡೇ ಮಾಡ್ಕೋತಾರ್ರಿ, they are the sons of the through the second wife. ಹೌದಾ? ಡಿಫರೆಂಟ್ ಅಂದ್ರೆ ಯಾರು? ಅಂದ್ರೆ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು ಅವ್ರನ್ನ, ನೀವು ಮಾಡೋರು, ನಿಮ್ ವಿಟ್ನೆಸಸ್ ಅವ್ರು. ಹೌದಾ? ನಿಮ್ ವಿಟ್ನೆಸಸ್ ಹೇಳ್ಸಿದ್ರೆ ಅದನ್ನ ಅಡ್ಮಿಷನ್ ಅಂತ ತೊಗೊಳಕ್ಕಾಗತ್ತಾ? PW1 ಏನಾರು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ, ಕೇಳೋಣ. ನೀವ್ ಯಾರನ್ನೋ ಒಬ್ರು ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು ಬಂದು ನಿಮ್ ಪರವಾಗಿ ಬಂದು ಹೇಳಿ, ಇಲ್ಲ ಎಲ್ಲ ಒಂದು ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾಕೆ ಅಡ್ಮಿಷನ್ ಇದ್ದಿರೋದು? ದಟ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಆಯ್ತ್ರಿ, ಫೈನಲ್ ಡಿಗ್ರಿ ಆಗಿದೆ, ಬಟ್ ಏನ್ ನೀವು ಗ್ರೌಂಡ್ ಹೇಳಿ, ವಾಟ್ ಈಸ್ ದಿ ಸೋರ್ಸ್? ಈಗ ನಿಮ್ದೇನ್ ರಿವೆನ್ಸ್ ಇಲ್ಲ ಐಟಮ್ ನಂಬರ್ 6ಗೆ ಏನ್ರಿ? ಬೋನಾಫೈಡ್ ಪರ್ಚೇಸರ್ ಮತ್ತೆ ಅವನಿಗೆ ಲೀಗಲ್ ನೆಸೆಸಿಟಿ ಸೇಲ್ ಆಗಿದೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ಐಟಮ್ ನಂಬರ್ 6 ಹಾಕಿಲ್ಲಲ್ಲ, ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಹಾಕಿದ್ದೀರಿ, ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆಯಾ? ಎಲ್ಲಿದೆ? ಮತ್ತೆ ನೀವು ಅದಿದ್ರೆ ಎರಡು ಒಟ್ಟಿಗೆ ತಗೋಬೇಕಾಗುತ್ತೆ. ಯಾಕಂದ್ರೆ ಈಗ ಇದನ್ನೊಂದು ಡಿಸೈಡ್ ಮಾಡೋದು ಮತ್ತೆ ಅದನ್ನೊಂದು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ, ಒಟ್ಟಿಗೆ ಬೋತ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸೈಡೆಡ್ ಟುಗೆದರ್. RSA ಅದು 18 ಮತ್ತೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇದುವರೆಗೂ. ನೋಡೋಣ, ಅದನ್ನು ಲಿಸ್ಟ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ಬರ್ಲಿ ಎರಡನ್ನು, ವಿಲ್ ಡಿಸೈಡ್. ಏನ್ ಸ್ಟೇಕ್ ಕೊಡ್ಬೇಕ್ರಿ? ಅಲ್ಲ ರೀ, ನೀವು ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ತೋರಿಸಿ, ಸ್ಟೇ ಮಾಡ್ತೀನಿ. ಎಕ್ಸೆಪ್ಟ್ ದಿ ನಿಮ್ ಪ್ರಕಾರ DW2 and 3 evidence ಬಿಟ್ರೆ, those who are your witnesses and admittedly property family was having the properties, joint family property, and also the defendant number 1 is the karta of the family and he was not having any employment. ಆಯ್ತು, ಕಾಟನ್ ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ ಇನ್ಕಮ್ ಬಂತು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು? ಬರೀ ನಾನು ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ ಇದೆಯಾ ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ, ಇದೆಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದಿರಾ ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ? ಐ ವಾಸ್ ಗೆಟಿಂಗ್ ದಿ ಇನ್ಕಮ್ ಫ್ರಮ್ ಮೈ ಕಾಟನ್ ಬಿಸ್ನೆಸ್ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಏನಿದೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್? ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್. ಏನ್ರಿ FDP ಫೈನಲ್ ಇದೆಯಾ? ಅಲ್ಲ, ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದಾರ ಕಮಿಷನರ್. ನಾಟ್ ಟು ಡ್ರಾ ದಿ ಫೈನಲ್ ಡಿಕ್ರಿ ಅಂತ ಮಾಡ್ತೀನಿ, ರೆಕಾರ್ಡ್ಸ್ ಪುಟ್ ಅಪ್ ಆಗ್ಲಿ ಮಾಡೋಣ. ದಿ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ವಿತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ವುಡ್ ಸಬ್ಮಿಟ್ ದಟ್ ಅದರ್ RSA 1739 of 2018 is also connected to this appeal. Hence, registry is directed to put up the same along with this appeal. The counsel appearing with the appellant would submit that the commissioner has already been appointed and the survey report is also given and matter is listed for day after tomorrow for drawing up a final decree. And in view of the submission, the trial court is directed not to draw the final decree till next date of hearing and list these two matters on 17 to ಅವತ್ತು ಹೇಳಿ ನೋಡಿ ಎರಡು ಕೇಳೋಣ. 15th ಇರೋದು, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಲ್ಲ, ಯಾವಾಗಿರೋದು 16th. ನಾವೇ 15 ಕೇಳ್ಬಿಡ್ತೀವಲ್ಲ, ಮತ್ತೆ ಹಾಕ್ಬೇಕಿತ್ತು ಎಂಟ್ರಿ ಮಾಡಿ. ಆಯ್ತು 17th ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಯ್ತು 17th. ಅಂಡ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಅಲ್ಲೇನೋ ಬಂತಲ್ಲ ಮೇಡಮ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಂದ 2 days ಅಂದ 16th ಇದೆ ಅಂತ ಹಾಕೊಳ್ಳಿ. 16th or 15th? 16th ಇದೆ ಅಂತ. Matter is listed for admission along with delay application ಅಲ್ವಾ? ಹೇಳಿ ಪರವಾಗಿಲ್ಲ, ಹೇಳಿ ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ ನೋಡಿ. ಡಿಲೇ ಇದ್ರೆ ಮಾಡೋಣ ನೋಟಿಸ್. along with the genealogical tree. Propositors is Chinnaya, alias Chennaya, Ramaya. He was having wife Kempamma and having 1, 2, 3, 4, 5 children. 5 children only. One of the son Venkatesh is no more, and his wife is Puttadayamma. Puttadayamma is the second defendant. Who died? Pannamma. No issues, sir. No issues. Plaintiffs only Venkatalakshmamma. Venkatalakshmamma plaintiff and Gauramma. The daughters have filed a suit for the relief of partition. Against the 2 brothers, that is Venkatesh and Hannaya. Venkatesh is no more, and his wife. Right. Right. Only 1 to 5. Already partitioned. Item 1 and 2. 2 and 4. Grant. Item. Other. Already there was a partition. Partition in the year 83-84 or 93-94? 83-84. Right. Right. Pain. Granted in favor of whom? 2 sons. Grant in which year? 94. These plaintiffs are married prior to that? 35 years back. But only granted relief in respect of 1 and 3 and 5. Hmm. 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 Hmm.
And this particular mutation was not challenged by any. Therefore, in terms of validity, I don't know. Here to the implemented. But again, therefore, it requires cannot be considered. There is a variation between the countries. But the return document is, though it is not marked, there is no definite indication.
Return document ಏನು? ಪಂಚಾಯತ್ ಪಾರ್ಟಿಷನ್. ಪಂಚಾಯತ್ ಪಾರ್ಟಿಷನ್ ಅಂದ್ರೆ ಪಂಚಾಯತ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಯ್ತು ಅಂತನಾ? Issue notice. And main also. And also main. Yeah, settlement ಅಂತ ಯಾವುದು serial number 39. ಹೇಳ್ರಿ, why you want council time? ಆಯ್ತು, previous ಆದ್ರೇನು? You are appearing for whom? 2019 matter. Suit for partition. Dismissed, confirm. Order sheet ಕೊಡಿ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಒಕ್ಕಲತ್ತು ಹಾಕಿದ್ರ 23rd. ಏನು ಟೈಮ್ ಕೇಳ್ತಾರಲ್ಲ ಒಂದ್ಸರಿ ನೋಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಥರ್ಡ್. The appellant counsel seeks time on the ground that he could not able to secure the records and earlier advocate was no more. And appellant respondent counsel is also present. Discuss matter on 24th.
In RA 5/19 from 18/11/2019. Property payment for 40. Granted, grandfather. Put up year 1932, the approved for 9/1932. Thereafter, the father was changed in his name, order number 4, dated 13/8/1932. After that, the certificate was transferred in the name of the Baira. After the result of Baira, the property was in his son, the name Manjal. After from the year 1945 to 1991, the property as of the property. And column number 9, with his name, copy Karabwar. In the year 1991, it was died. After that, the appellant, the son of the Manjar, did not pay the revenue of the property. In the year 95-96, requirement number 6.
ಸರಿ, ನಿಮ್ ಪ್ರಕಾರ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಹೌದಾ? On perusal of exhibit P1, it is seen that the grant made to the grandfather of the plaintiff in survey number 40 measuring 1 acre 37 quintas is mentioned as darkhast. However, the plaintiff has not produced any corresponding grant certificate or document of title. The ILR mentions the said survey number as Kafi Karab, and there is no mention of the said number in the RR. The RTC also shows it as Sarkari Bilu. The RTC is from exhibit.
1991 onwards, he has not paid the revenue. Entered in the column number 9.
Sarkari Bilu ಮಾಡಿದ್ದಾರೆ.
After that, here he filed the application for regrant in favor of him. Also change the khata in his name.
ರೀಗ್ರಾಂಟ್ ಆಗದಲ್ಲೇ ಖಾತಾ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ? ನಾವು ಪ್ರಾಪರ್ಟಿ ವೆಸ್ಟ್ ವಿತ್ ದಿ ಸ್ಟೇಟ್ ಅಲ್ವಾ? ಸರ್ಕಾರಿ ಬೀಳು ಅಂತಂದ್ರೆ ದಾಖಲೆ ಏನಿದೆ ರೀ? ದಾಖಲೆ ನೀವು ಪೊಸಿಷನ್ ಇದೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸೂಟ್. ಆಯ್ತು, ಇರ್ಲಿ ರೀ. ಪೊಸಿಷನ್ ಏನಿದೆ ದಾಖಲೆ ಅಂತ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರಿ ನೀವು? ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನೀವು ಇದೀರಿ ತೋರ್ಸಕ್ಕೆ. ಕೇತವಾರ ಅದು ಮೊದ್ಲಿಂದದು. ಅದು ಬಿಟ್ರೆ ಈಗ ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ದಿ ಸೂಟ್ ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಪೊಸಿಷನ್ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಇದೆ ರೀ? ಪೊಸಿಷನ್ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಇದೆ? An adjacent land owner to prove his possession of suitable property. Further, the plaintiff is also not due diligent in paying tax to the government. ಏನು ಮಾಡಿಲ್ಲ. 91 ಆಯ್ತು ರೀ. ಸೂಟ್ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಇದು, ಬೇರೆ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹೌದಾ? ಮತ್ತೆ ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಸೂಟ್ ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಹಾಕಿದ್ರಿ? Different number of 6 have made entries in RTC with regard to the scheduled property as Sarkari Bilu from 1996-97 as per exhibit 96-97 ಸರ್ಕಾರಿ ಬೀಳು ಆಗಿದೆ ಇದು. ಮತ್ತೆ ಈಗ ರೆಸ್ಟೋರ್ ಆಯ್ತಾ ನಿಮ್ದು? ಮತ್ತೆ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದು ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಆಯ್ತು, ಗ್ರಾಂಟ್ ಆದ್ರೆ ಬನ್ನಿ, ಆಮೇಲೆ ನೋಡು. ಈಗೇನಿಲ್ಲ, ಆಲ್ರೆಡಿ ಪ್ರಾಪರ್ಟಿ ವಾಸ್. ಏನ್ ಮಾಡದ್ರಿ? ಏನು ಇಲ್ವಲ್ಲ, ನೀವು ಟ್ಯಾಕ್ಸೇ ಕಟ್ಟಿಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಸರ್ಕಾರಕ್ಕೆ ಹೋಗಿದೆ, ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ? ಏನಿಲ್ಲ. ಬಿಲಾಂಗ್ಸ್ ಹೌದು.
And number 13, the judgment.
Injunction notary, as on the date of the suit, you should be in possession, and then there must be an interference. But the property was fallen to the government in the year 95-96 itself. Physical possession is ilbekkala, ದಾಖಲೆ ಇರ್ಬೇಕಲ್ಲ. even not examined any neighbor are also you have not. That is the observation of the appellate court also. ವೈಫ್ ಆಯ್ತ್ರಿ, ಪಕ್ಕದ ಜಾಗ ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅಂತ ಹೇಳಿ ನಿಮ್ಗೆ ಹೆಂಗೆ ಇಂಜೆಕ್ಷನ್ ಕೊಡಬೇಕು? ಆರ್ಡರ್ ಆಫ್ ತಹಸೀಲ್ದಾರ್ ಏನಂತ? Including this land reserved for the burial. ಆಯ್ತು, ಈ ಲ್ಯಾಂಡ್ ಇದೆಯಾ? Yaudri, land, this land also. But already government, government or already disposed the property. Exhibit D4 CC of the order antiದೆ. ಅದರಲ್ಲಿ ಈ ಸರ್ವೆ ನಂಬರ್ ಸೇರಿಲ್ವಾ ಮೇಡಮ್ ಇದೆಯಾ ನೋಡಿದಿರಾ ಯಾವ ಪ್ಯಾರ ಓದ್ತಾ ಇದ್ರಿ ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮೇಡಮ್ OSL page ಪ್ಯಾರಾ ನಂಬರ್ ಏನು ಪ್ಯಾರಾ 17 huh? He is the owner of social property. The revenue documents produced by him do not show that he is in possession of the same. On the other hand, the exhibit D4 shows that the villagers are using the social property as burial ground. Therefore, the plaintiff has filed to prove this possession.
The cloth exemption of TW1.
Burial ground and same is ordered by the Tahsildar to be reserved as burial ground. In order to prove the same, the defendants have produced exhibit D4, wherein the Tahsildar has directed that the proposal be sent to the DC for reserving the suit schedule property as burial ground. It should be noted that plaintiff of this case is also a party to the said proceedings. It is observed by the Tahsildar that on spot inspection he found dead bodies burnt. Therefore, by keeping all these things in mind, I answer point number 2 as affirmative.
The point number 30. Cloth exemption of TW1. He has admitted that the documents in revenue department are under his custody. Copies are given on application. He has admitted that exhibit P1 to 18 are given by revenue department. He has stated that oldest document is RR. He has admitted that only by an order the entity in K2R can be changed. He has admitted that the RR related to survey number 40 mentions it has copy corrupt. However, it does not year of he has admitted that D3 survey number was granted to Baira.
ಆಯ್ತ್ರಿ ದರ್ಖಾಸ್ತು ಆಗಿದ್ದೆಲ್ಲ ಆಯ್ತು ಬಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಪೇಡ್ ದಿ ಟ್ಯಾಕ್ಸ್ ಗವರ್ಮೆಂಟ್ ವಾಸ್ ಆಯ್ತು ಅದೇನು ಟೈಟಲ್ ಡೀಡ್ ಅಲ್ಲ ಬಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಇಸ್ ದಟ್ ನೋ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ವೆಸ್ಟ್ ವಿತ್ ಹಿಮ್ ನೋಡಿ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ admission. I heard the council appearing for the appellant and also the council appearing for the state, that is HGP. The factual matters of case of plaintiff before the court that he is in possession and enjoying this property, social property, and same was granted by the government through Darkas number 9 of 1931-32 to the name of Baira alias Bairappa, son of Putta. The Khata has changed as per order number 24, dated 13/8/1932. So after his death, the name of his son Manja, alias A.B. Manjappa, was entered in RTC. But in column number 9, it is shown as copy Karab. A.B. Manjappa from 1968-69. A.B. Manjappa died on 4/10/1991, after which plaintiff has not paid the land revenue. In 1996, the defendant number 6 entered the column number 9 of RTC as Sarkari Bilu. The setback came to the knowledge of the plaintiff on 3/9/2007, and immediately he filed necessary application before defendant number 6. But defendant number 6 did not take any action. Hence, the plaintiff sent an application dated 4/11/2012 to the Registrar of High Court of Karnataka, and the matter was referred to the High Court Legal Aid Committee. The committee took opinion of Desai and Associates on 21/22 and has transferred the dispute to the TNSC, Mudigere. The case was registered as PLC number 3 of 2013. The defendant number 6 appeared before the committee and filed objections, but has not agreed to change the Khata of scheduled property to the name of the plaintiff. Hence, the dispute was closed as not settled. The defendant number 6, without any title or interest, was trespassing into the scheduled property and removing the fence. Immediately after filing of the suit, defendants appeared and Defendant number 6 filed written statement contending that on verification of revenue documents, 1 acre 37 kuntas of land in survey number 40 was granted under Darkhast in favor of Baira son of Putta and younger son Manja. The same is mentioned in Ketwa, but in the index of land, the said land is mentioned as Kafi Karab. And also in RTC for the year 1968 to 95, the land is shown as Kafi Karab. However, unauthorizedly, the Kata has been mutated to the name of A.B. Manjappa. But the said mutation entries are not mentioned in any mutation register. The plaintiff also submitted an application 39/2007 to restore the Kata of the said land. As per the order dated 19/8/2012, the application of the plaintiff was disposed of. Since the property was reserved for the usage of burial ground, and the same is ordered to be reserved for the use of public as burial ground. Defendants neither now they have trespassed the social property, and defendants have also issued an endorsement for the legal notice dated 6/9/2016 stating that Kata cannot be mutated in favor of the plaintiff. Having considered the pleadings of the parties, the court also raised issues and also the plaintiff examined himself as PW1 and got document exhibit P1 to 43. On the other hand, DW1 is the one witness is examined by the defendants, that is DW1, and document exhibit D1 to 4 are got marked. The trial court, after considering both oral and documentary evidence, comes to the conclusion that plaintiff has not been in possession of the suit property, and answered issue number 2 that property is used by the public for the purpose of burial ground, and declined to pass the order of the injunction on the ground that the plaintiff has not established the possession over the suitable property while answering issue number 4 and 5, and dismissed the suit. Being agreed by the judgment and decree, an appeal is filed which is numbered as RA 5 of 2019. The appellate court also, on reappreciation of both oral and documentary evidence, comes to the conclusion that the property vests with the state on account of non-payment of the tax, and subsequently property is also reserved for public burial ground. And also, in order to establish the possession, no witness of adjoining landowner also been examined before the trial court. And also, the plaintiff has not paid the tax to the government, and hence property belongs to the share of property belongs to the government. And hence, no ground is made out, and dismiss the appeal. Being agreed by the judgment and decree of the first appellate court, trial court, and also the first appellate court, the present appeal is filed. Counsel appearing for the appellant would vehemently contend that both the courts have committed an error in not considering the document of exhibit P1 Ketwa, and also counsel would submit that both the courts have not considered both oral and documentary evidence available on record. And also counsel submits that the revenue document stands in the name of plaintiff grandfather name and plaintiff father name, and not getting the proper report of coffee crops and trees stands in the suit and property, and after the death of the father of the plaintiff, he has not paid the revenue, and the very observation of the trial court and the appellate court is erroneous, and hence it requires interference. The counsel also submits that the substantive question of law arises for the consideration of this court is that both the courts have committed an error and failed to appreciate the evidence available on record and ignoring the material on record past the judgment. Hence, it requires interference. For contrary, the counsel appearing for the state which submits that the trial court and also the first appellate court taken note of the evidence available on record, and particularly comes to the conclusion that no document stands in the name of the plaintiff, and admittedly the property is fallen to the government on account of non-payment of tax in the year 1995, 96 itself, and thereafter the application filed in 2007, and in the meanwhile already land is reserved for public usage for use of the same for burial ground. And Tahsildar also made inspection and also found the property is used for public burial ground. And both the courts have taken note of the material available on record and given the definite finding that plaintiff is not in possession of the social property. And hence it doesn't require any interference. Having heard the appellant counsel and also the counsel appearing for the state and also on perusal of material, suit is filed for the relief of their injunction in respect of extent of 1 acre 30 guntas, excluding Karab 7 guntas. Excluding Karab 7 guntas of land. And it is the claim of the plaintiff also that the land was granted in favor of the grandfather of the plaintiff. And also the same is not disputed by the defendants in the written statement and admitted that land was granted in favor of the grandfather of the plaintiff. And also not disputed the fact that property was fallen to the government on account of non-payment of tax. The trial court as well as the first appellate court taken note of in terms of document exhibit D1. Scheduled property is mentioned in column number 9 as Sarkari Bilu. Documentary evidence produced by the plaintiff that exhibit B8 RTC reveals that some other properties were mutated in the name of the plaintiff after the death of his father. Exhibit B8 reveals that the Kata of survey number 39/P mutated in the name of the plaintiff in the year 1999-2000. And trial court also, while considering the contention of the plaintiff, answering issues framed in paragraph number 9 and 10 discussed with regard to the documents which have been placed by the plaintiff. And also taken note of the evidence of the DW1 who led evidence before the court. Got marked document exhibit D1 to 4. In terms of exhibit D1 is this RTC of survey number 40 for the year 96 to 2001, which shows Sarkari Bilu in column number 9. Exhibit D2 is the ILR for survey number 40, which shows copy Karab. Exhibit D3 is the certified copy of Ketwar register, which is same as exhibit P1. And exhibit P4 is the order of Tahsildar reserving 1.37 acres in survey number 40 as burial ground. The trial court, taking note of all this material available on record, comes to the conclusion that first of all, title deed of the original grant has not been produced before the court. And apart from that, no documents available before the court on the date of filing the suit. The plaintiff has been in possession of the property and taken note of exhibit D4, for which the property was reserved for public usage for burial of the dead body. And answered issue number 1 as negative and issue number 2 as affirmative in coming to the conclusion that property is used for burial ground. And also issue number 4 and 5 with regard to the possession also comes to the conclusion that plaintiff failed to prove that he is in possession over the social property. Dismissed the plaintiff. The first appellate court also on reappreciation of grounds urged by the appellant before the appellate court, considering and considered the both oral and documentary evidence and taken note of the material on record and exhibit, and in paragraph number 16 discussed the disputed fact is that whether scheduled property is copy Karab or not. The document also discloses that defendant wrongly entered copy Karab, but to do the same, the plaintiff not produced any document regarding making of entry. the appellate court also in paragraph number 17 taken note of the property was mentioned as Sarkari Bilu from 1996-97 as per Exhibit D1. And no doubt the appellant counsel contend that application is filed for restoration of the property. But no such any order has been passed restoring the property in favor of the plaintiff. And in order to prove the fact that he has been in possession of the property also, except examining himself as PW1 not examined any of the witnesses. The same is also observed in paragraph number 18 by the appellate court that possession also has not been proved. Having considered the material and record, and relief is sought for the permanent injunction. And at the time of granting the permanent injunction, court has to see the documents, whether the property is in possession of the plaintiff as on the date of filing of the suit, and whether there is any interference. And when the material discloses that scheduled property was taken away by the government in the year 1996-97 itself, mentioning the same as Sarkari Bilu as per Exhibit D1. And apart from that, Exhibit D4 also very clear that Tahsildar has reserved the scheduled property for the usage of the general public for burial ground. And when such being the case, and Exhibit D1 and D4 also not challenged by the plaintiff, and in order to prove the factum of possession as on the date of the suit, no material is placed before the trial court and even in appellate court also. And both the courts have taken note of both oral and documentary evidence, and also the evidence of PW1 and DW1. And document placed by the defendant also establishes that the scheduled property become government land in the year 96-97 itself, and thereafter no such document is evident to show that the plaintiff has been in possession of the property. And instead of Exhibit D4 discloses that Tahsildar of Mudigere passed an order to reserve the said land for the public usage, and hence rightly comes to the conclusion that the defendants have proved their contention while answering issue number 2 as affirmative. And hence I do not find any error on the part of the trial court as well as the first appellate court, and material considered by the trial court and the first appellate court based on the documentary evidence as well as oral evidence, and no perversity is found in the finding of both the trial court as well as the first appellate court. And hence I do not find any ground to invoke section 100 to admit and frame substantive question of law. In view of the discussions made up, I pass the following order. Appeal is dismissed. Okay. ಮಾಡ್ಕೋಬಹುದು, ನೀವು ಚಾಲೆಂಜ್ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದ್ದೀನಿ ಅಷ್ಟೇನೆ. ಅಷ್ಟೇ ಲಿಬರ್ಟಿ ಏನು ಸ್ವಲ್ಪ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಯು ಕ್ಯಾನ್ ಚಾಲೆಂಜ್ ಇಟ್. ಜಸ್ಟ್ 41 ಯಾರು ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ ಇದಾರಾ? ಹೇಳಿ. ಹೌದು, ಹಾಕಿದ್ದೀರಾ? ಯಾವಾಗ? ಆಫೀಸಲ್ಲಿ ಹಾಕಿ ತಗೊಳ್ಳಿ. The appellant counsel submits that today is going to file medical records with regard to the delay, and if it is filed, put up the same. List is 17 to 42. Here. What is this? ಏನದು? ಏನಿದು? ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ ಈಗ? ನೋಟಿಫಿಕೇಶನ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ? ಓಕೆ, ಆಯ್ತು. ಅವ್ರೇನು ಹೇಳಿದೀನಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ನೀವು ನೋಡ್ರೆ ಅಲ್ಲ ನಿಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವ್ರು ಹೇಳಿದಾರ ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಮಾಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ ಅಂತ. ಹಾ ಅವ್ರೇನಂದ್ರೆ ಅವ್ರು ರೆಡಿ ಟು ಆರ್ಗ್ಯೂ ಆಯ್ತು ಪಾಸ್ ಇರ್ಲಿ ಬಿಡಿ ಮಧ್ಯಾಹ್ನ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಟ್ ಹಾ ಹಾ ಎಲ್ಲಿ ಮುಗಿಸ್ಕೊ ಬನ್ನಿ. ಇವನ್ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ. ಅಲ್ಲ ಅವ್ರು ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊ ಬನ್ನಿ, ಮುಗಿಸ್ಕೊಂಡೇ ಬನ್ನಿ. ಯಾಕೆಂದ್ರೆ ಅವ್ರ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. ಹಾ ಹ್ಮ್ ಹ್ಮ್ ಬರ್ಲಿ ನೋಡೋಣ ಅದರ್ ಸೈಡ್ ಬರ್ಲಿ. ಹ್ಮ್ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಟ್ 2:30 ಹೇಳಿ.
I have for the appellant. In fact, I am ready. Limit Munjal. He is out of town. He called me on phone.
ಡೇಟ್ ಕೊಟ್ಟಿರ್ಬೇಕು ನೋಡ್ರಿ ಬೆಳಗ್ಗೆಲ್ಲ. ಅವ್ರು ಹೇಳಿದ್ರು ನಾವು ಟೈಮ್ ಕೊಡಿ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೇವೆ.
ನನ್ನ appellant ಸ್ವಾಮಿ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಹಾ ಹೇಳಿ 34. Okay, why you want time? Last time press time, no date. ದಿನ ಬಂದು ಡೇಟ್ ಕೇಳಿದ್ರೆ ಐ ವಿಲ್ ನಾಟ್ ಎನ್ಕರೇಜ್ ಸಚ್ ಅಟಿಟ್ಯೂಡ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಅನ್ಸ ನಾನು ಅದಕ್ಕೆ ಬರ್ಕೊ ಬರ್ತೀನಿ, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೇ ಬರ್ಕೊ ಬರ್ತೀನಿ. ಆರ್ಡರ್ ಶೀಟ್ ರೆಕಾರ್ಡ್ಸ್ ಏನೇನಾಗಿದೆ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರ್ಕೊ ಬರ್ತೀನಿ. ನೋ ಕೌನ್ಸಲ್. ಡಿಸ್ಮಿಸಲ್ ಕನ್ಫರ್ಮ್. ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್, ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜಂಕ್ಷನ್ ಕೋರ್ಟ್ ಎಲ್ಲ ರಿಲೀಫ್ ಆಗಿದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಆಯ್ತು, ಲಾಸ್ಟ್ ಟೈಮು ಟೈಮ್ ಕೇಳಿದ್ರಿ, ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಈಗ ಮತ್ತೆ ಬೇಕು. ಆಯ್ತು ನೋಡಿ. Appellant counsel seeks time on the ground that he needs to secure some documents, and order sheet discloses that in the earlier occasion also sought time, and again he is seeking time. This matter on 17/2. ಮತ್ತೆ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. 17/2. 35 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ನೋಡಿ, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ರೀ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆಬ್ಸೆಂಟ್ ಅಂದಿತ್ತು. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲರ್ ನೀವ? ಇಲ್ಲ ಏನ್ ಗೊತ್ತಿಲ್ಲ. ಸೇಲ್ ಬೈ D1 and D2 null and void ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸಿಕ್ಯೂಟ್ ದಿ ಸೇಲ್ ಡೀಡ್ ಅಂತ, ದಟ್ ಇಸ್ ಕನ್ಫರ್ಮ್ಡ್ ಇನ್ ದಿ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ. Respondent counsel seeks time on the ground that he has written letter to the party and appellant counsel is present. Is this matter on the other date kodi madam? 24th. 24/2. ನಿಮ್ದೇನೋ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಇದ್ರು, ಅವ್ರಿಗೆ ಕೇಳಿದೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೆ, ಅವ್ರಿಲ್ಲ ಟೈಮ್ ಬೇಕು ಇನ್ನೇನು. ಮೋಸ್ಟ್ಲಿ ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀನಿ? 24th. ಏನ್ ನೀವು ನೋಡ್ತಿರಲ್ಲ ಕನ್ಕರೆಂಟ್, ಯಾವ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ರು ಎಲ್ಲಾ RSA ಬರ್ತವೆ. ನಾನು ಅದನ್ನೇ ಹೇಳಿದ್ದು, ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇದ್ದು ಮತ್ತೇನಾದ್ರು ಪರ್ವರ್ಸಿಟಿ ಇದ್ರೆ, ಈಗ ಮೆಟೀರಿಯಲ್ ಇದ್ದು ಕನ್ಸಿಡರ್ ಮಾಡ್ದಲ್ಲೇ ಬೋತ್ ದಿ ಕೋರ್ಟ್ಸ್ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಆಗ ಇಟ್ ಕಮ್ಸ್, ಅದರ್ವೈಸ್ ಬರೋದಿಲ್ಲ. ಏನ್ ಮಾಡೋದು? ಇನ್ವೇರಿಯಬಲ್ ಎಲ್ಲಾ ಇದ್ರ ಮೇಲೂ ಅಪೀಲ್ ಬರುತ್ತೆ. RSA ಹೈಕೋರ್ಟ್ ಪಕ್ಕದಲ್ಲೇ ಇದೆಯಲ್ಲ, ಬರುತ್ತೆ. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಬೆಂಗಳೂರಲ್ಲ, ಕರ್ನಾಟಕ. ಬೆಂಗಳೂರಿನವ್ರು ಬರಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಅವ್ರಿಗೆ RFA ಬಂದ್ಬಿಡುತ್ತೆ. ಬೆಂಗಳೂರಲ್ಲೆಲ್ಲ RFA. ಬಟ್ ಇನ್ವೇರಿಯಬಲ್ ಬೆಂಗಳೂರಲ್ಲಿ ಏನ್ ಡಿಗ್ರಿ ಆಗುತ್ತೋ, ಒಂದು 100 ಡಿಸ್ಪೋಸಲ್ ಆದ್ರೆ ಒಂದು 90 RFA ಬಂದ್ ಬೀಳ್ತಾರೆ. ವೆರಿ ರೇರ್ ಬೀಳದೆ ಇರೋದು ಅಷ್ಟೇ. ಈ ಪಾರ್ಟೀಸ್ ಅಮಿಕಬಲಿ ಸೆಟ್ಲ್ಸ್ ಆವಾಗ ಮಾತ್ರ ಬರಲ್ಲ, ಅದರ್ವೈಸ್ ಬರುತ್ತೆ. ಈಗ ನಮ್ಮಲ್ಲಿ ನೋಡಿ ಬೆಂಗಳೂರಲ್ಲಿ ಒಂದು ಆಲ್ಮೋಸ್ಟ್ ಒಂದು ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್ ಒಂದು 100 ಇದೆ. ಅದ್ರಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಅಪೀಲ್ ಬರುತ್ತೆ. ದಿನ ಒಂದೊಂದು ಎರಡೆರಡು ಡಿಸ್ಪೋಸಲ್ ಆದ್ರೂ ಒಂದು 100 ರೆಗ್ಯುಲರ್ ಅಪೀಲ್ ಬಂದ್ಬೀಳ್ತಾವೆ ಡೈಲಿ. RF ಅಷ್ಟೇ, ಬೆಂಗಳೂರಿನಲ್ಲೆಲ್ಲ RF, ಅಲ್ಲೆಲ್ಲ RA ಆಗಿರುತ್ತೆ. ನಾನು ಹೇಳೋದು ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ಗೆ ಸ್ವಲ್ಪ ಸೀಟಿಂಗ್ ಈಗ ಸ್ವಲ್ಪ ಜಡ್ಜಸ್ ಜಾಸ್ತಿ ಆಗಿದಾರಲ್ಲ, ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕು RF RS ಗೆಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಕಷ್ಟ. ಆದ್ರೆ ಕಷ್ಟ ಕಷ್ಟ. ಇವೆಲ್ಲ ಜೂನಿಯರ್ಸ್ ಗಳಿಗೆ ಸ್ವಲ್ಪ ರೆಡಿ ಮಾಡ್ಬೇಕು. Hmm. 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 Right. Reset. Note. 34 ಅಲ್ಲ appellant counsel seeks time and sorry, respondent counsel seeks time and appellant counsel also present and says no objection. List after 2 weeks. 230 list ಇದೆ ಅಲ್ಲ. Okay. HCGP is directed to take notice and file objections if any. This matter on next Wednesday ಅಲ್ಲ. 15 to second one also same first time. See for Sandeep S. Patil, that is also same. ಯಾವುದು ನೋಟಿಸ್ ಹೋಗೋದು ಯಾವುದು ಇಲ್ಲ ಅಲ್ಲ. Just Abdul Ansar. Earlier order I'm having copy.
What?
ಕೊಡಿ. ಮೇಡಮ್ ಪೇಜ್ ನಂಬರ್ 3 ಎರಡು 14 ಇದು 3 ಇದು 2 ಅಲ್ಲ ನಮ್ಮ ಆಫೀಸ್ ಹಾಕೋತೀನಿ ಮುಂಚೆ ನೋಡ್ಬೇಕು. 302 also. Hmm. Hmm.
Not initiate page number 28.
Hmm.
Trial court order.
Trial court order.
Trial court order.
Hmm. Hmm.
Page number 28.
Hmm.
It is alleged the complaint. Farid
Page number 28.
Page number 28.
Huh.
It
is alleged in the
In
complaint.
page 10. In page 10.
First line.
Hmm. Right?
Hmm.
It is alleged that
Farid.
Farid while one Miss Hafiza is the younger sister of one Afnan, and in that regard, you warning is that Farid is that Afnan called Manoj and one Razak to Ayyapanagar. When the accused number 1 to 4 were in the pleading of Ayyapanagar, the third Afnan, Manoj and Razak questioned the accused number 2 as to why he is sending message to Afnan. At that time, Galata started and accused number 1 to 4 asserted Afnan, Manoj and Razak hands. At that time, accused number 1, Salim took out a weapon which was kept in his motorcycle and assaulted on the leg of Razak. When Manoj tried to intervene the Galata, accused number 1, Salim assaulted on his head with the said weapon and Manoj sustained bleeding injury and fell down. And when he was taken to Niman's hospital, Manoj died on the way to hospital. The accused number 1 to 4 were arrested. The entire allegation is accused number 1. Accused number 3, 4, 5. Sorry, 3, 4. Assaulted on the hand and hands. Result of the hands. ಹಾಗಾಗಿ ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿಕೊಂಡು ಅಲ್ಲಿ ನಾವು ಏನು A2ಗೆ ಪ್ಯಾರಾ ನಂಬರ್ 2 ಪೇಜ್ 3 ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 2 ಅಲ್ಲೇ ಓದಿ. Brief facts of the case are that the informant Sri Mahesh lodged first information against.
ಇದೆಲ್ಲ ಬೇಡ, ರೀಸನ್ ಹೋಗಿ ಸರ್, ರೀಸನ್ ಹೋಗಿ ಏನ್ ರೀಸನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆರ್ಡರ್ ಮಾಡುವಾಗ. ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಬೇಡ, ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ವಿ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಡೆಲ್ಟ್ ವಿತ್.
ಅಂದ್ರೆ ಅವರು ಹ್ಯಾಂಡಲ್ ಮಾತ್ರ ಇದಾಗಿದ್ದಾರೆ. ಇದು ಏನು ಅದರ್ ಎಲ್ಲಾ ಮೆಟೀರಿಯಲ್ಸ್ ರಿಕವರಿ ಆಗಬೇಕು.
ರೀಸನ್ಸ್ ಹೋಗಿ ಹಿಂದೆ ರೀಸನ್ಸ್.
Even though the FIR was registered against accused number 1 to 4, the charge sheet was came to be filed against accused number 1 to 10, making specific allegations against each of the accused. The specific override committed by the present is also mentioned in column number 13 of the charge sheet. The contention of the letter counsel for the petitioner that petitioner has not committed any offence cannot be accepted at this stage. However, as per the charge sheet, it is only accused number 1 who assaulted the iron rod and caused his death and also caused injury to complainants 16, 17 and 18. Even though it is alleged that the present petitioner had also assaulted the injured and the deceased, it is not with any weapon, but only with hands. No incriminating materials were recovered at the instance of the present petitioner. It is not the contention of the prosecution that the petitioner is required to be detained in custody for any purpose except ensure his presence before trial. There are about 47 witnesses cited in the charge sheet. Their examination before
in the order 41/27. Hence, the registry is directed to secure the records of lower court as well as the first appellate court. And this matter on 24 to. Yes. ತೋರಿಸಿದ್ರ ಅವ್ರಿಗೆ ಫೋಟೋ?
My photograph. You know, here all structures where I had out. Here down which I'm given a then we had some. Okay. I'm not a student. Super intention is filed by me. And they pull me out of the premises.
Told. Registry is directed to secure the records, trial court and also the appellate court.
Can you record the statement? Not change the nature of property.
Counsel appearing for the appellant would submit that. ಏನು ನಿಮ್ ಪ್ರಕಾರ ಅವ್ರು ಏನು ಅಲಾಟ್ ಮಾಡಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ?
ಪ್ರಾಪರ್ಟಿಲಿ any tenants may be called for and they want to pick up a structure and give it for tenants.
ನೋಟಿಫಿಕೇಶನ್ ಎಲ್ಲ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ ಅವ್ರು. ವಿಡ್ರಾ ಮಾಡಿದೀವಿ ಅಂತ. ಆಯ್ತು ಅದನ್ನ ತಗೋತೀನಿ. ಅದನ್ನಾಯ್ತು ನೋಡಿ. Counsel appearing for the appellant would submit that the respondents have cleared the suit schedule property and making efforts to rent out the said area, and in this regard they have issued the notification also. The counsel appearing for the respondent would submit that they are not going to let out the said area, and also notification issued was also withdrawn. Hoda? By an amendment 10/10/2022, and hence the said submission is recorded and list this matter on 23rd of February. ಆಯ್ತು. ಲಿಸ್ಟ್ ಅಪ್ ಟು 2 weeks ಆಗ್ಬೋದಾ ಅಥವಾ ಡೇಟ್ ಬೇಕಾ? ಡೇಟ್ ಕೊಡ್ರಿ. ಯಾವ್ದಾದ್ರು ನಾರ್ಮಲಿ ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ನವ್ರಿಗೆ ಡೇಟ್ ಕೊಡಲ್ಲ ನಾನು, ಅವ್ರು ತಗೋಬೇಕು, ಅದಕ್ಕೆ ಹಾಕೋಬೇಕು. ನಮ್ದೇನೇ ಇದ್ರು ಮಾತ್ರ ನಾವು ರೋಸ್ಟರ್ ನಾನು ಡೇಟ್ ಕೊಡೋದು. 24th ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಅದಕ್ಕೆ ಹೇಳಿ. 8th ಅಲ್ಲ 24th. ಈಗ 8 weeks, ಆಮೇಲೆ 8 weeks. ಅದಕ್ಕೆ January to February 8 weeks, ಆಮೇಲೆ 8 weeks. ಕಾಲ್ ಆಫ್ಟರ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ 2 weeks ಅಂದ್ಬಿಡ್ತೀನಿ. ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks. Right. Next, 43, Veena Kumari M. Non-prosecution. This matter was listed on 24/1/23. This court has observed that on 9/1/23 also. No, 9/1/23 proxy counsel for the appellant sought time on the ground that counsel on record was not keeping well. And also no representation on 24/1/23. However, this court in the ends of justice given one more opportunity to prosecute the matter, failing which the appeal will be dismissed for non-prosecution. And today also no representation. And in view of the preemptory order, dismissed for non-prosecution.
Directed third copy upon the respondent counsel.
Madhura, counsel appearing for the appellant submits that he has served the copy of the appeal memo on the Kiveta counsel on Yavaga. On 4th of February. Acknowledgement there.
The online delivery status report is
Huh?
given paying for 3 months.
By post ಕಳಿಸಿದ್ದೀರಿ ಏನಾಯ್ತು ಮೇಡಮ್ ಅಲ್ಲ ಸೆಂಟ್ ಅಂತ ಹೇಳಿ ಸರ್ವ್ಡ್ ಅಲ್ಲ ಸೆಂಟ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಅಪೀಲ್ ಮೆಮೊ ಥ್ರೂ ಪೋಸ್ಟ್ on 3/2/23 and also produced copy of the postal track. Then served on Thidiya.
Yes, sir, delivery confirmed.
And the same was delivered on 4/2/23. And office also has shown the name of the Kiveta counsel and counsel not present. However,
Your Lordship, Your Lordship appearing for Kiveta, Your Lordship, respondent.
yes, counsel.
The Kiveta is not feeling well, so need time of a week, Your Lordship. So we could find the wakalat in time.
ವಕಾಲತ್ ಕೆವೇಟ ಹಾಕಿದಿರಲ್ಲ ನೀವು ಮತ್ತೆ ಯಾಕೆ ಒಂದ್ಸರಿ ವಕಾಲತ್ ಹಾಕ್ಬೇಕು.
Okay, Kiveta is not feeling well, so we need time of a week.
ಆಯ್ತು ಮೇಡಮ್ counsel filed on postal track and the counsel appearing for the respondent appeared through VC and seeks 1 week time. And hence this matter on date 24/2 counsel.
Much available.
6.
Whatever the parties, it is not binding. As per permanent. But the boundaries are mentioned. Are those different properties that we require. Like that, sorry. My whereas according to the from the others, it also means that I have removed depends on the person. And you know, what all the evidence will be available in one of these good schedule are positive. And you know, the prior court comes to the conclusion there is a mistake in the boundary. But still it puts that handling the finding of the prior court at para 19.
Para 19.
The contention of people that the boundaries are not.
Para 19.
Okay,
that when the property was purchased by Lakshmipati, property was not Pakka Podi, and after Pakka Podi, the boundaries. But there is no document indicating that there was a Pakka Podi. Because of which the boundaries have changed. The defendants to disprove the boundaries have not been given. The defendants to the document evidence placed by the plaintiff. This will be P4, P15 and P8. P4 are the mutation and article. They won't find any boundaries. P15 is the same. The boundaries mentioned in P15 are different from what is mentioned in suit sheet. And the exhibit is a submission of the earlier suit, which was declared in my favor in respect of property. That has become final. Now what is happening is by giving wrong boundaries in respect of property. And contending that both the courts have granted the degree in respect of the boundaries mentioned in the suit sheet. That is what I am agreeing. And the earlier suit in 487 of 2011, they were party. If they were party, assuming that they were party, what was the remedy? Remedy was either to file an appeal or to file a dismissal. Then they filed a separate suit for a declaration that the remedy is not binding. But these are the aspects which have even the appellate court also, so far as this particular boundary is concerned. Kindly see the reason of the appellate. Paragraph 17. This is the approach of the appellate counsel vehemently argued that the boundary shown in the
Para.
in page 28. Paragraph 17. The appellate counsel vehemently argued that the boundary shown in the daily dated 21/8/1978 and the schedule are not tallying with each other. The boundaries will not remain static, and properties have been passed from one hand to another, and consequently boundaries also change. During the course of the Pakka Podi, also boundaries change. Thus, for the it cannot be held that the plaintiff has paid to ownership of schedule. And hence, here the boundary of the northern side, because the land of the defendant is the southern side of the defendant, survey number 100. In both areas of the city, it is stated that on the southern side, remaining land in survey number 190 bar 2 is not correct. In the plain schedule, what is mentioned is survey number 190 bar 1. It is the case of the plaintiff that after the Pakka Podi, it is numbered as survey number 190 bar 1. That is not this case. This case is after this one and this 190 bar 2A. So the entire approach is contributing. Court agree on a presumption that when the property changes, the boundaries will change by a granted degree. In respect of
Podi document and hakilwa.
the earlier commissioner's report also in the earlier that shows that my property on the southern side, on the western side, there is no property.
Northern side.
Northern side allowed.
Both chain deed and schedule of the plaint, it is stated that on the southern side, remaining land in survey number 119 bar 2 ಅಂತಿದೆ. 2A ಅಂತಿದೆ. North ಗೆ 2A, southern side ಗೆ 119 bar 1 ಇದೆ. 19 bar 2 ಅಂತ ಹೇಳ್ತಾರೆ.
My land is on the western.
Notice. To notice. To notice, and in the meanwhile, get the records of the trial court and also the appellate court.
On the basis of property within the schedule mentioned in the suit schedule, they are trying to interfere with my position. That is the reason why I am taking for it.
The documents fully known, will examine.
Yes. On the face of it, the findings by the trial court. The first trial court says, I am supposed to disprove their bound. In spite of having given a conclusion that yes, there is a discrepancy in the boundaries, in the pleadings and also in the document. That is the only angle.
Only but discrepancies with regard to the boundaries is concerned.
Correct.
But you are also not disputing. You are also not disputing the title of the plaintiff.
Sold under exhibit B, but not in respect of the land as shown. That is the difference. I can't dispute them because there's already a sale deed and all that.
ಸೇಲ್ ಡೀಡ್ ಬೌಂಡ್ರಿ ಏನಿದೆ?
ಸೇಲ್ ಬೋರ್ಡ್ ನಮ್ಮ ಸದರ್ನ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ.
ಸೇಲ್ ಡೀಡ್ ತೋರಿಸಿದಾಗ
ಹಾ,
ಕೊಡಿ ಮೇಡಮ್, ಸೇಲ್ ಇದು
ಸೇಲ್ ಕಾಪಿ ಇದೆ.
ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ ಕಡೆಗೆ? ಹೇಳಿ, ಈಸ್ಟ್ ಏನಿದೆ? ಹಾ,
ಭೈರಪ್ಪನ ಜಮೀನು,
ಭೈರಪ್ಪ
ಭೈರಪ್ಪನ
ಸೇಮ್ ಇದೆ.
ಹಾ, ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 165 ನಂಜೇಗೌಡರ ದಿಕ್ಕಿಲಿ
165.
165.
ಹ್ಮ್.
ದಕ್ಷಿಣಕ್ಕೆ ಇದೇ ನಂಬರ್ ನಾವು ಉಳಿಸಿಕೊಂಡಿರುವ 1 ಎಕರೆ ಜಮೀನು, ಕಾಫಿ ಜಮೀನು.
ಹ್ಮ್.
ಉತ್ತರಕ್ಕೆ ಭೈರಪ್ಪನ ಜಮೀನು. Now what is happening is they are trying to describe totally a different boundary, and that is an admitted fact. That is what the trial court also has given a finding. But trial court pakka kodi the agite pudike na avakaಶ है.
ಪಕ್ಕಾ ಪಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಹಾಕಿಲ್ಲ.
Just thinking that because of pakka kodi boundaries might have changed.
Heard the appellant counsel on IA 1 of 22, wherein made this court to say the operation and execution of the judgment and decree dated 16/7/2018. Huh? Then defendant is appellant. 16/7/2018. Passed by the learned civil judge, and also the judgment and decree of RA 88 of 2022. The council would submit that the plaintiff has purchased the property under exhibit P15. And the boundary shown in exhibit P15 is different from boundary shown in the suitable property. And also council brought to notice of this court except the eastern boundary, other boundaries which have been mentioned on the west, south and north are different boundaries. And hence it is appropriate to stay the judgment and decree of trial court as well as the first appellate court in the next rate of hearing. List the matter after 2 weeks of happening. List the matter immediately after securing the records for admission along with the lower court records. Please Antappa Basappa. Council.
Number 98. Dentist of the younger company, Mahesh Barapa.
Okay.
From different, there are several studies. Studies. The dependence of care and analysis of the dentist. Issue. Are you issues? They are the owners and position of the group, several there and the property. The other place that everything of the dependent. That should finally independent. There are plenty for everybody for the direction. Examined. Three witnesses. Of the 1 to 3.
Yes.
And produce their documents. Exhibit A1 to exhibit B26. That matter step now. So what's in the kindly see, there are 13 of the trial court judgment. The trial court has heard that in that 25 to the title and in the approved corner of the Thane Summary number 98, 96 and 100. That declared the source model. Against which model that dependence of record and everything is our court. Our court model. They will be finding. Don't have another the plaintiff shall fail to do the exhibit P1. This is map now. Author is not examined. And it told that registered 78 months. Recital is not concerned. That are the accounts of 2 points, reverse the findings. And this is the short model. I cannot read that about this appeal. That in para 13, you know, para 13 of the law court judgment. Establish that claim.
Anyhow, we'll secure the records and then we'll list the matter for admission.
They have interfere unnecessary. I am in the position of the title follow the position follow the title. Let's just send it around. They are daily interfering with the position. So short for that injunction. Short for declaration. He is not first. He has to.
Reversing of decree. Yes, reversing of decree. Whether was there any temporary injunction in trial court? Trial court al injunction ittendri. Trial court al temporary injunction itta. Whether you are having interim order in the trial court. Interim order itu ಅದು ಕನ್ಫರ್ಮ್ ಆಗಿದ್ರೆ ಆಯ್ತು ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಶಿವಮೊಗ್ಗ 24th. ಆಯ್ತ್ರಿ the question is now whether you have enjoyed the relief of temporary injunction. ಏನಂತ ಅದಕ್ಕೆ that's why I am asking you whether you have enjoyed the relief ಅಂತ. ಆಯ್ತು ವೆರಿಫೈ ಮಾಡಿ ನಿಮ್ ಪ್ರೇಯರ್ ಇಸ್ ಓನ್ಲಿ ನಿಮ್ ಪ್ರೇಯರ್ ಏನು ಹೇಳಿರೋದು ಜಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಅಷ್ಟೇ ಕೇಳಿರೋದು. ಮತ್ತೆ ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನೋ ಹೇಳ್ತಾರಲ್ಲ
ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಅವ್ರು ಸುಮ್ಮನೆ ಬಂದಿರು
ಸುಮ್ಮನೆ ಬಂದವ್ರು ಏನು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು. ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೇನೆ ಏನಾದ್ರು ಕೇಳಿ ಹೇಳಿ. What I asked. So I asked. He says only the appeal ಅಲ್ಲಿ ಏನಾದ್ರು ಎಂಟ್ರಿ ಮಾಡಿರ್ತಾ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಇತ್ತ? Have you enjoyed the relief of temporary injunction before the trial court? ನೋಡಿ ಹೇಳಿ ನೋಡೋಣ. ಆಯ್ತು. Then I will consider IA 1 of 22. Passed over, ಆಯ್ತು. Preliminary hearing B group. ಏನ್ರಿ ಇದು ಮಳಸರ್ಲು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇತ್ತು. ವೈ ಯು ಆರ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಥಿಂಕ್ ಐ ಡೈರೆಕ್ಟೆಡ್ ಯು ಟು ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ವಾ? ಇಲ್ವಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನೀವು. ಯಾಕೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯಾರು ನೀವೇನ? RHA ನಲ್ಲಿ ಇದೆಯಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ ನೋಡಿ. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. WP ಬ್ರಾಂಚಿಗಾರ ಹೋಗ್ಬೇಕು, ಇಲ್ಲ RSA ಬ್ರಾಂಚಿಗಾರ ಹೋಗ್ಬೇಕು. ಎಲ್ಲಿ ಫೈಲ್ ಇದೆ ಅಲ್ಲಿ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು. ನಾನೇ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ? ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಮತ್ತೆ ತಗೊಳ್ಳಿ. The counsel appearing for the appellant in RSA 80 of 2017 is given 1 week time to comply with office objections. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಏನಿದೆ? ಇನ್ನೊಂದು ಸೆಕೆಂಡ್ ಒನ್ ಯಾವ್ದು ಇದೆ? ಅದೇ ಹಾಕಿರೋದು ನೀವು ಹಾಕಿರೋದ ಮೇಡಮ್? ಸೆಕೆಂಡ್ ಒನ್ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಯಾವುದು ಇಲ್ಲ. ಯಾವಾಗ ಎಷ್ಟು ದಿವಸ ಬೇಕು? 10 days. 10 days ತಗೊಳ್ಳಿ. 10 days ಅಂತ ಹಾಕ್ಬಿಡಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. 23rd of February. ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ? ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ ಇದ್ರಲ್ಲಿ? ನೀವೇನಾ? ತಗೊಂಡ್ಬಿಡಿ, ನೋಟಿಸ್ ತಗೊಂಡಿ. ಕೌನ್ಸಿಲ್ ಕೆ ಶ್ರೀಹರಿನಾ? ಶ್ರೀಹರಿ takes notice in RSA 3880 of 2017 for all respondents. The appellant counsel is directed to serve the copy of RSA forthwith. And in the meanwhile, within 10 days, comply with office objections. In the meanwhile, within 10 days, comply with office objections in RSA. And this the matter on 23rd of February.
49.
There is an agreement one. Agreement of sale. Agreement of sale provides period of 9 months. Time is fixed for performance, 9 months. Pay the money and have to state it exit. Then what happens is within the period of 9 months, on 14/9/2007, they say that the supplementary agreement 3 people have signed, some further money is paid. Then on 5/2/2010, there is an endorsement. This is the crux of my argument. There is an endorsement signed by first up. Check. Now, I will not go into the again repeat the question where I said these are not my signatures, court has not compared the signatures which ought to have done under 70. I come to only this. If the Lordship takes the paper book, my lord, plain. Page number 2 of the paper. So this is very crucial for what I will propose. Defendants are the absolute owners. One, agreement is made with all the appellants. I'm only using defendants are the absolute owners. Same paragraph, 8 lines, 4 lines. The defendants have agreed to sell the property. But then, your Lordship, should see is, please come to page number 6, just above paragraph number 4. Unfortunately, defendant number 1 and other defendants have not shown any inclination to execute the sale deed. Page number 7, 6 lines at the top. Defendants did not come forward. Defendants, so now, whom do they claim against? They claim against all the appellants. Claim for specific performance against all the appellants. So whatever happened is that, then please come to page number 127. This is the basis of the legal argument. Page number 127. This is the legal notice issued by them on 5/8/2010. Second paragraph, that all of you, being the absolute owners of the scheduled property, have expressed your desire. You have not done so. The word all of you appears page 128, page 1 everywhere. 128, third line, all of you have agreed. Page 129, 4 line, 5 lines from the bottom. My client demanded all of you to come and execute the schedule. And then page 130, second last line. Thus, all of you are called upon to come and execute the last, second last. That all of you are called upon to come and execute. Page 130. 129 only 5 lines from the bottom. 129 only 5 lines from the bottom. That is, my client demanded all of you to come and execute this.
But I have already underlined it. When you have argued on the last occasion, I underlined.
Now, please come to page 137. Now, this, why I say this? Now that the endorsement of 5/2/2010 has to be explained. You know, first notice is second notice, page 137, second paragraph. It is submitted that the first of you, being the Karta and manager of the joint family, are received. This is an attempt to say that the receipt of 50,000 by one person was sufficient. However, if the Lord sees your claim, there is no reference to Karta, there is no reference to manager, nothing. This is first defendant receipt. Now, the question is this. Article 54 of the Limitation Act says this. It's all my argument. I won't take it. Article 54 says, for specific performance, 3 years, time from which period begins to run, the date fixed for performance. Exhibit P1 says, that is 7 July 2007, April, that is 16/7/2007 is the agreement. 15 April 2008, the time expires. And then 3 years. So 14 April 2010, they should have 2011, they should have filed the suit. The suit is filed on 19/7/2011. Is beyond the period of limitation. Now, as regards, now what they do is that 5/2/2010 is the savior. Now, what is the status? Section 18 where before the expiration of the period for a suit or application. That is before the period, yes, 5/2/2000 before. In respect of any property or right, an acknowledgement of liability is made in respect to such property, or right has been made, right, signed by the party against whom such property or right is claimed. But the words used are, against whom do you claim the right? Against all the defendants. The acknowledgement of liability has the effect of extending limitation under section 18 to be signed by all the persons against whom the plaintiff claims the right. Now, the acknowledgement is not made by all the persons against whom the plaintiff is claiming the right. In the suit, plaintiff claims right against 6 people.
Whether that acknowledgement within 3 years? Within 3 years. That is only by one person.
That's why I read out the claim in the plaint is against 6 feet. The first legal notice is 6 feet. The concept of karta is therefore a new concept, but they don't include it in the plaint. And even in the second notice, they don't say why they didn't talk of karta. They don't say why they didn't talk about why didn't you talk of karta in the plaint. Explain why got it left out. Missile something. There is nothing. The plaint is signed. Once the plaint is and if the acknowledgement is rely upon signed by one person, it is not signed by everybody against whom they claim. So therefore, my submission is, even assuming I am not able to prove that the signatures are forged, no, I find it difficult. Not forged. The question remains this is the only document under which they can bring the suit within time. Suit is barred by time. I am entitled to the relief. Dismissal of the suit on ground of limitation. So, you know the
The case is protected to the therefore, when exhibit P1 was executed, he has taken signature. Convert into P2. What the issue? The exhibit P2 and its claim connect stand paper which has been taken subsequent to exhibit P2. That is dated. That's great. And there when the exhibit people was saying this land paper was not available. It was subsequently taken. On 13/9/2007. That paper was taken on 13/8/2007. What about stood? Taking over the conduct of the defendant. The falsely written statement. Turn down the contention with regard to exhibit P2. Exhibit P3 is a shara which has been written in continuation with exhibit P2 on the very document and it is written. What should I kindly say? Exhibit P3 that Money number 23 ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಮಾಪನ ಅಧಿಕಾರಿಗಳಿಂದ ಕ್ರಮವಾದ ಖಾತೆ ಮಾಡಿಸಲು ಇನ್ನೂ ಕಾಲಾವಕಾಶ ಬೇಕಾಗಿರುತ್ತೆ. ಹಣದ ಅವಶ್ಯಕತೆ ಇದ್ದು ನಿಮ್ಮಿಂದ ಈ ಕೆಳ ಸಾಕ್ಷಿಗಳ 50,000 ರೂಪಾಯಿಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. ತಿಂಗಳ 2,50,000 ರೂಪಾಯಿಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. There are two things this year. This document, one document which are necessary and essential affecting legislation. We need time. We need time. With this background, the evidence of cross-examination of BW1 is read. Please stop. Yes.
74.
SLC ಒಂದು ಶಿಕ್ಷಣ ಪಡೆದಿದ್ದೇನೆ. 3ನೇ ತರಗತಿ BSc ಪದವೀಧರ. ನನ್ನ ಹೆಣ್ಣು 5ರಿಂದ 6 ನೇ ತರಗತಿಗಳು. ನಮ್ಮ ಮುಖ್ಯ ವಿಚಾರಣೆಯ ಪ್ರಮಾಣ ನಾವೇ ಹೇಳಿ ಕಳಿಸಿದ್ವಿ. ನಮ್ಮ ಲಿಖಿತ ಪ್ರಕರಣದಲ್ಲಿ ದಿನಾಂಕ 14/2/2007 ಸರಿ. ಅದೇ ದಿನ ಪ್ರತಿವಾದಿ 1ರಿಂದ 6 ಸಹಿಯನ್ನು ಆಕಾರವನ್ನು ಮಾಡಿರುವ ಸಲುವಾಗಿ 50 ಚಾಪಕಾರದ ಮೇಲೆ 2 ಪುಟಗಳಲ್ಲಿ ಸಹಿ ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. 50 ರೂಪಾಯಿ ಕೆಲಸ ಸಿಗಲಿಲ್ಲ. ಆದರೆ ಲಿಖಿತ ಪ್ರಕರಣಕ್ಕೆ ಆಯ್ದ ಸಹಿಗಳನ್ನು 50 ಚಾಪಕಾರದ ಮೇಲೆ 1 ಲಕ್ಷ ಮತ್ತು 50,000 ಎಂದು ಹೇಳಿದ್ದೇನೆ ಸರಿ. ಪ್ರಶ್ನೆ ಕೇಳಿಸಿ ಸಾಕ್ಷಿದಾರರಿಗೆ ಎಕ್ಸಿಬಿಟ್ P2 ಮತ್ತು P2 ಸಾಕ್ಷಿದಾರರು P2 ಮೇಲೆ ಇರುವ ಎಕ್ಸಿಬಿಟ್ P2A ಸಹಿ ನಮೂದಿಸಿದ್ದು ಎಕ್ಸಿಬಿಟ್ P2B ಮತ್ತು P2 ಮತ್ತು ಸಾಕ್ಷಿದಾರರಿಗೆ ಸಭೆ ಸಹಿಗಳನ್ನು ಯಾವಾಗ ಮಾಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ ಪ್ರಶ್ನೆಗೆ ಅವರು ತಮ್ಮಿಂದ ಮೋಸದ ಸಹಿಗಳನ್ನು ಪಡೆದು ಎಂದು ನುಡಿದಿದ್ದಾರೆ. ನಾನು ಲಿಖಿತ ಪ್ರಕರಣದಲ್ಲಿ 50 ರೂಪಾಯಿ ನಾನು ನನ್ನ ಲಿಖಿತ ಪ್ರಕರಣದಲ್ಲಿ ಖಾಲಿ ಚಾಪಕಾರದ ಮೇಲೆ ದಿನಾಂಕ 14/2/2007 ಸಹಿ ಪಡೆದುಕೊಳ್ಳುವುದು ಎಕ್ಸಿಬಿಟ್ P2 ಚಾಪಕಾರದ ಪತ್ರ. ನಮ್ಮ ಗ್ರಾಮದ ತಮ್ಮಣ್ಣ ಮತ್ತು ಮುಂದಿನ ರಂಗೇಗೌಡರ ಮಗ ನಾರಾಯಣಗೌಡ ಆಟದಲ್ಲಿ ಮತ್ತು ನಮ್ಮ ನಡುವೆ ಯಾವುದೇ ಮೈಮರಿಸಿಲ್ಲ. ನಾಗೇಂದ್ರ ಹಾಗೂ ನಮ್ಮ ನಡುವೆ ಯಾವುದೇ ಮೈಮರಿಸಿಲ್ಲ. ಮೇಲಿರುವ ಪ್ರತಿವಾದಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4ರಿಂದ 6 ಸೈಗಳು ಯಾವಾಗ ಮಾಡಿರ್ತಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ಲಿಖಿತ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರತಿವಾದಿ 4ರಿಂದ 6 ಸಹಿಗಳನ್ನು ಸಹ ನಮ್ಮ ಪಡೆಯಲಾಗಿದೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. P2 ಮತ್ತು P3 ಮೇಲಿರುವ PL ಸ್ವಾಮಿ ಎಂಬ ಸಹಿಗಳನ್ನು ಕನ್ನಡದಲ್ಲಿ ಇವೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿದಾರರು ಮುಂದುವರಿದು P3 ಸಹಿಗಳು ತಮ್ಮದಲ್ಲ ಎಂದು ಹೇಳಿರ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ P3A ಮತ್ತು P3A ಸಹಿಗಳು ನನ್ನದೇ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P2 ಚಾಪಕಾರಗಳನ್ನು ನಾನು ಹೆಸರಿನಲ್ಲಿ ಸರಿಯಲ್ಲ. ಈಗ ಪತ್ತೆ ದಿನಾಂಕ 13/9/2007 ಪಡೆಯಲಾದ ಚಾಪಕ P2 ಎಂದರೆ ಸಾಕ್ಷಿದಾರರು ಪಡೆದುಕೊಂಡಿಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. 14/2/2007 ವಾದಿ ನಮ್ಮಿಂದ ಖಾಲಿ ಚಾಪಕಾರದ ಸಹಿ ಪಡೆದುಕೊಂಡಿದ್ದು 2007 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ವಾದಿಯಿಂದ ಪಡೆದ ಎಕ್ಸಿಬಿಟ್ P2 ಅನ್ನು ಬರೆದುಕೊಂಡಿದ್ದು ಸರಿಯಲ್ಲ. 25/2010 50,000 ರೂಪಾಯಿಗಳನ್ನು ಒಂದು ಕಡೆಯಿಂದ ಅದು ಸಿಪಿಐ ಬರೆಸಿ ಸರಿಯಾಗಿ ವಾದಿಗೆ ನಾವು ಮಾರಕ್ಕೆ ಒಪ್ಪಿದ ಜಮೀನಿನ ವಿಸ್ತೀರ್ಣ 18 ಗುಂಟೆ 30 ತಿಂಗಳು ಒಳಗಾಗಿ ಒಪ್ಪಿದ್ದೆವು. ತೊಂದರೆ ಇರುವ ಕಾರಣದಿಂದ ಅದೇ 9 ತಿಂಗಳ ಒಳಗಾಗಿ ಪ್ರಯತ್ನ ಬರೆದು ನನಗೆ ಹೇಳಿದ್ದರು. ಅಕ್ಷರಗಳಿಗೆ ಒಂದು ಹೊಸ ಬದಲಾವಣೆ ನಮ್ಮ ಜಮೀನಿಗೆ ಹೋದಾಗಿ ಒಪ್ಪಿದ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸದರಿ ದಾಖಲಾತಿಯನ್ನು ಎಕ್ಸಿಬಿಟ್ P-17 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಎಕ್ಸಿಬಿಟ್ P-17 ಈ ಆಕಾರ P-17 ಗುರುತಿಸಲಾಯಿತು. ನಾವು ಕರೆದ ಕರಾರು ಬರೆದುಕೊಂಡ ಸಂದರ್ಭದಲ್ಲಿ ಆಕಾರ ಬಂದು ಹಾಗೂ ಆರ್ಟಿಸಿಗಳಿಗೆ ಹೊಂದಾಣಿಕೆ ಇರಲಿಲ್ಲ ಅಂದರೆ ಸರಿ. ಆಕಾರ ಬಂದಲ್ಲಿ 19 ಗುಂಟೆ ಮತ್ತು ಆರ್ಟಿಸಿನಲ್ಲಿ 18 ಗುಂಟೆ 18 ಗುಂಟೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿದಾರ ಮುಂದುವರೆದು ತಾವು 18 ಗುಂಟೆಗೆ ಒಪ್ಪಿದ್ದಾಗಿ ನಿಂತಿರುತ್ತಾರೆ. ನನ್ನ ಲಿಖಿತ ತಕರಾರು ಸದರಿ ವ್ಯತ್ಯಾಸವನ್ನು 9 ತಿಂಗಳ ಒಳಗಾಗಿ ಸರಿ ಮಾಡಿಸಿದ್ದೇವೆ ಎಂದು ಹೇಳಿದ್ದೇವೆ ಎಂದರೆ ಸರಿ. ಆಕಾರ ಬಂದು ಹಾಗೂ ಆರ್ಟಿಸಿ ವ್ಯತ್ಯಾಸಗಳನ್ನು ದಿನಾಂಕ 23/3/2009 ಪ್ರಕಾರ ಸರಿಪಡಿಸಲಾಗಿದೆ ಎಂದರೆ ಸಾಕ್ಷಿಗಳು ಅದನ್ನು ಸೃಷ್ಟಿಸಲಾಗಿದೆ. 2009 ಮುಂದೆ ನಾವು 9 ತಿಂಗಳ ಒಳಗಾಗಿ ಸದ್ಯ ವ್ಯತ್ಯಾಸವನ್ನು ಇರುವ 19 ಗುಂಟೆ ಜಮೀನು ಬಗ್ಗೆ ಒಪ್ಪಿದ್ದು ಸರಿ ದಾಖಲೆ ಎಕ್ಸಿಬಿಟ್ P-80 ಹಳೆ 42/92/94 ಪಿ ಇದ್ದ ನೋಡಿ ಸರ್ವೆ ನಂಬರ್ 163 ನಮೂದಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಆರ್ಟಿಸಿ ನೋಡಿ ಒಪ್ಪಿದ್ದು ಎಕ್ಸಿಬಿಟ್ P-19 ಆರ್ಟಿಸಿ ಪಿ ಸರ್ವೆ PL ಸ್ವಾಮಿ ಎನ್ನುವ ಬದಲಿಗೆ AL ಸ್ವಾಮಿ ಎಂದು ಆಗಿರುವುದೆಂದರೆ ಸರಿಯಲ್ಲ. ದಿನಾಂಕ 26/3/2010 ನಮ್ಮ ಹೆಸರು ತಿದ್ದುಪಡಿ ಕೊಟ್ಟು ನಾನು ತಿದ್ದುಪಡಿ ಮಾಡಿಸಿಕೊಂಡಿದ್ದೆ ಎಂದರೆ ಸರಿ. The revenue documents came to be corrected only on 26/3/2010. P-17 ಅದರ ಬಗ್ಗೆ MR ನಂಬರ್ 2 ಸಾಕ್ಷಿ ಒಪ್ಪಿಕೊಳ್ಳಲು ಎಕ್ಸಿಬಿಟ್ P-20 ಎಂದು ಸೂಚಿಸಲಾಯಿತು. 2010ರವರೆಗೂ ನನ್ನ ಜಮೀನು ದಾಖಲಾತಿ ನಡೆದಿದೆ ಸರಿಯಲ್ಲ. ದಾಖಲಾತಿಗಳು ಸರಿ ಇಲ್ಲದೆ ಪ್ರಯತ್ನ ನಾವು ವಾದಿಗೆ ಕೈಪತ್ರ ಮಾಡಿಕೊಂಡು ಆಗಿಲ್ಲ ಎಂದರೆ ಸಾಕ್ಷಿ ವಾದಿಗೆ ನಮ್ಮ ಬಳಿ ಕೈಪತ್ರ ಮಾಡಿಸಿಕೊಳ್ಳಲು ಬಂದಿರಲಿಲ್ಲ ಎಂದು ಸಜೆಷನ್. 2010ರಲ್ಲಿ ವಾದಿ ನಮ್ಮ ಬಳಿ ದಾಖಲಾತಿಗಳು ತಿದ್ದುಪಡಿ ಆಗಿವೆ, ಈಗ ಕೈಪತ್ರ ಬರೆದುಕೊಡಿ ಎಂದು ಬಂದಿದ್ದು ಸರಿಯಲ್ಲ. ದಾಖಲಾತಿಗಳು ತಪ್ಪು ಆಗಿರುವ ಪ್ರಯತ್ನ ಅವುಗಳನ್ನು ಸರಿಪಡಿಸಲು ನಾವು ಒಂದು ಬಾರಿ 1 ಲಕ್ಷ ರೂಪಾಯಿ, ಇನ್ನೊಂದು ಬಾರಿ ಮತ್ತೊಂದು ಬಾರಿ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕಡೆಯನ್ನು ಪಡೆದು ಎಕ್ಸಿಬಿಟ್ P-20 ಬರೆದುಕೊಟ್ಟು ಸರಿಯಲ್ಲ. ನಾವು skip up 1 page. Welcome to page number 7. ನಾವು ವಾದಿಗೆ ಕೈಪತ್ರ ಬರೆದುಕೊಳ್ಳಲು ಇಷ್ಟಪಟ್ಟಿದ್ದು ವಾದಿಗಳಿಗೆ ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್ ಜಾರಿ ಪಡಿಸುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ನೋಟಿಸ್ಗೆ ನಾನು ಆ ಸಮಯ ಜಾರಿಗೊಳಿಸಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ನೋಟಿಸ್ನಲ್ಲಿ ನಾನು 50,000 ಕಾನೂನಿಗೆ ಕಾಣಿಸಿದಂತೆ ಜಾರಿಗೊಳಿಸುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನೋಟಿಗೆ ಸಹ ನಾನು ಉತ್ತರ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ತಿಂಗಳ ಒಳಗಾಗಿ ವಾದಿಗೆ ನಾನು ಬರೆದು ಸಿದ್ಧ ಎಂಬುದಾಗಿ ಹೇಳಿ ಯಾವುದೇ ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸಿಲ್ಲ. ಸಾಕ್ಷಿದಾರರು ಮುಂದುವರೆದು ತಾನೇ ಸಿದ್ಧಾಗಿ ವಾದಿಗೆ ಬಳಿ ಅದರ ಬಗ್ಗೆ ಹೇಳಿಕೊಳ್ಳಬಹುದು. ವಾದಿಗಳನ್ನು ಭೇಟಿ ಮಾಡಿದ ಆ ನಂತರ ನಾನು ಪ್ರಯತ್ನ ಬರೆದಿರುವ ಬಗ್ಗೆ ಸಾಕ್ಷಿದಾರ ನಾನು ಸಿದ್ಧಾಗಿ ಹೋಗಿದ್ದು ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸುವುದೇ. ನಾನು ಯಾವತ್ತೂ ಸಹ ವಾದಿಗಳಿಗೆ ಹೋಗಿ ನಾನು ಕೈಪತ್ರ ಬರೆದುಕೊಳ್ಳುವುದು
ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ ಅಲ್ಲ. ಅದೇ ಗುದ್ದಾಗಿ ನನ್ನ ಮನೆ ಬಂದು ಹಾಕೊಂಡು ತಿದ್ದುಪಡಿ ಆಗುವ ಮೊದಲು ಇದ್ದ ಕಾರಣಗಳು ಸರಿ 2009 ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ. ಈ 6 to 8 ಇದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ 14 ದಾಖಲಾತಿ ಮಾಡಿ ಮೋಸ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಹಾಕಿದ್ದೇನೆ. ಎಕ್ಸಿಬಿಟ್ 6 ರಲ್ಲಿ ಈ 6 ರಲ್ಲಿ ಏನೇ ತೀರ್ಮಾನ ಆಗಿದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಂವಿಧಾನವನ್ನು ಅದೇ ಮಾಡಿಕೊಂಡಿದ್ದು ಸರಿ. ಸರಿ ಅದಕ್ಕೆ ಇದೆ ಪರಿಹಾರ ಆಗಿದೆ. Only dependent have only. They are shown at 3-4 places. As if there is some controversy between the parties on the defendants. The defendant number 1 has filed a statement. His written statement has been adopted by other defendants on 26/11/2011. 26/11/2011 by filing a memo. That apart from examining myself, I have also examined the attesting witnesses slightly. They withstood for the cross-examination that they did. Not facing everything. For the possible up to 26/2010. And exhibit P3, they themselves were requested for execution of time. There was a mistake in the legal notice issued by us, and it has been corrected by issuing a rejoinder. That rejoinder has been issued on the earlier to issuance of reply by the other side. Now, reply the cross examination they admit about exhibit P2 and P3 also, and basically. So therefore, nothing wrong in the judgment which has been rendered by the prayer court and which has been affirmed by the first appellate court. Therefore, person of interfering with the judgment of the court below. And attesting witnesses also which to for the class.
Another bucket and another more. But learned friends are very attractive. But it seems to be against the division benefit. They are 1962 Mysore, page 246. Here on that, we get it. There is exhibit P1. Let us assume there is no forgery. Let's assume it there. Exhibit P1 is signed by everybody. Exhibit P2 is signed by 3. Exhibit P1 is signed. Let's accept. Nowhere in exhibit P1, P2, or P3 is it stated that there are errors in the revenue records.
P3 endorsement.
There is nothing contained in any of these documents that I will correct some errors. I will correct some boundary measurements. There is nothing. Now, all the cross-examination he led in would not have been permitted by the trial. Reasons like this. 62 Mysore, what happens there is
ಇದು ಅದೇ ಓದಿ ಹೇಳಿದ್ದು ಆಯ್ತು.
It has come to that. Signed by one person, it's not binding on others. What happens is, when there is a document, I can read section 92 prohibits oral evidence from being let into explain a document. It can explain some ambiguity in the document. It cannot permit you to read external evidence to share what are the circumstances surrounding that thing, how the document should be construed. It is not permissible to do. Whatever my learning from read is hit by section 92 of the evidence. That judgment is very clear. Though they say no, it's not one. I want the entire judgment. So, this was there was a Vishwas by a document. Vishwas where the terms of the document evidencing the transaction are specific, clear, and unambiguous. They speak for themselves, unnecessary to consider the meaning and connotation of those terms by reference to the intention of the parties expressed by either the surrounding circumstances or the conduct of the parties. But in case of doubt or ambiguity in the terms of the document, in order to interpret the terms, one has to resort to the order. The entire judgment of my learned friend is talking about surrounding circumstances.
Paragraph.
Entire judgment is that one. The entire judgment, in fact, both the learned judges, His Lordship Ahmad Ali Khan and Mir Iqbal Hussain, both give concurring judgments, each in his own words. And His Lordship Justice Mir Iqbal Hussain at one point. At paragraph 17, Lordship Ahmad Ali Khan, para 18, last portion, where the terms of a contract or a grant or other disposition of property have been reduced the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such a contract, grant or other disposition of property or such matters, except the document itself. What is the original document? Exhibit P1. No dispute. Exhibit P3 is executed by one person just because we find a common written statement doesn't. After I did this, doesn't mean that I am bound by it. Law is different. The acknowledgement says so. I have not said that I am acknowledged. Yes. My submission is yes. If we go by what he says in cross-examination, I may be barred by limitation. But the question is whether the cross-examination relates to the circumstances. What he's talking about is circumstances prevailing at the time of the agreement. Is that already data? Therefore, all that cannot be expect that line of cross-examination should not have been permitted by respectful submission because it is prohibited. Yes.
Please hold. Yes.
In the date 17. 26/3/2010. Exhibit P17. Invitation. Invitation with reference to correction has been effective only on 26/3/2010. So therefore, everything takes shape only subsequently. Immediately within 3 months from thereafter, we issue a notice. And the notice. Immediately thereafter, we have paid. After correction, they did not come back to execute this. Absolutely. But the extension is concerned, we covered in the- we have proved it. They also. This was a transaction of 2,000. One of lakhs has been paid. It is shown in the report. The liability is only 2 lakhs. Anything over and above. What can exercise the discretion and fix it? Implying pay before. So, compulsory.
Yes. What is that? ಏನಾಯ್ತು 47?
It's a shoot for only intention. I still have not gone into the court state. It's open for the party to file a suit. They can file a suit for today. Yeah, what can I file a suit? Yes, that's why I guess. In view of the personal relation, by virtue of the judgment in RSS, you can get a hearing. Your lordship has to snatch the money. I will pay for
Other respondents idara ಆಗ್ತಿದ್ದೀರಾ? ಏನಾಯ್ತು ಮೇಡಮ್? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? 47. ಹಾ, ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫಾರ್ಮ್ ಮಾಡಕ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬೇರೆಯವರು ಇವರು ಕೆವಿಯಟ್ R124 ಹಾಕಿದಾರಲ್ಲ, R124 ಹಾಕಿದ್ದಾರೆ. ಲೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಕಮ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಯಾವ್ದು ಶಿವಮೊಗ್ಗ ಅಲ್ಲ, ಲಿಸ್ಟ್ 24
Of this judgment. By the defendant. The defendant has contention that exhibit P2 was signed on 16/7/2007 and after examination and cross-examination it was brought out, it was subsequent to it. When there is a false play, the apex court has taken a view, para number 14, when they were live. As regards the false play of the defendant, the effect needs to be noted. It was treated by the defendant number 3 had gone to the house of the plaintiff number 2 allegedly prior to receiving any letter from the plaintiff and had spoken that they had told him that they were not keen of enforcing the application of exhibit A1. But when examined DW1, he said defendant number 3 admitted that he had never met the plaintiff as treated in the written statement or other defendant had never gone to the electorate to meet the plaintiff number 2 at his residence to speak about the performance of the contract. The plea stated in the written statement was abandoned in evidence. So it was noted that the conduct of the defendant cannot be ignored when paying the question of exercise of discretion for decreeing or denying the decree for special performance. So therefore, he has not approached the court with clean hands. ಅಲ್ಲಿ ನಾನು ಅವತ್ತೇ ರುಜು ಹಾಕೊಟ್ಟೆ ಅಂತ ಹೇಳಿದ್ರು. ಸ್ಟ್ಯಾಂಡ್ ಪೇಪರ್
ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಇದು ನೋಟ್ಸ್ ಇದೆ, ತಗೊಳ್ಳಿ. ಇನ್ನೊಂದು ಪೇಜ್ ಇದೆ ನೋಟ್ಸ್. ಎಸ್, ಫೈನಲ್ ಹಿಯರಿಂಗ್. RSA 38. Rupesh Kumar. ಇದು ಮುಂದೆ ಫಸ್ಟ್ ಬಂದಿರೋದು ಅಥವಾ 15 ಅದೇನ ಫಸ್ಟ್ ಬಂದಿರೋದು ಹಾರ್ಡ್ ಶೀಟ್ ತಗೊಳ್ಳಿ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದ ಮುಂಚೆ ಬಂದಿತ್ತ counsel for the respective parties are absent ibru irlilwa the appellant counsel is absent respondent counsel is present the appellant counsel also in the previous occasion was absent. The ends of justice, one more opportunity is given. List this matter on 24/2. If appellant counsel doesn't appear, appeal will be dismissed. ಏನ್ ಕೊಡ್ಬೇಕು ಪೇಪರ್ ಬುಕ್ ಆಫೀಸಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅಲ್ಲಿರುತ್ತೆ ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ಅಲ್ಲ ಮೇಡಮ್ ಅಲ್ಲಿ ಹಾಕಿರ್ತಾರ ಅಥವಾ ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲೇ ಇದೆಯೇನು ಒಂದು ಕಾಪಿ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ 2 ಇದ್ರೆ Sudan Rao, Shankar Narayan Bhatt. ಇಲ್ವಾ ಹ್ಮ್ 52 ಕಾಯ್ತಾ ಇದಾರ ಏನಾದ್ರು ಹಿಂಗಂತ ನೋಡ್ತಾರ ಅದೇ ಹೇಳಿದ್ರು ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ ಯಾವ್ದಾರು ಇದ್ರೆ ತಗೊಳ್ಳಿ 53 appellant counsel seeks time respondent counsel is absent this matter on 24/2 55 ಆಯ್ತಲ್ಲ 55 ಗಂಗಾಧರಪ್ಪ ಎವಿ ಪ್ರಕಾಶ್ ಆರ್ both the counsels are absent. This matter of 2 weeks ಅಂತ ಆಗ್ತದೆ ಅಷ್ಟೇ ರೇಟ್ ಕೊಡೋದು ಬೇಡ ಬರ್ಲಿಲ್ಲ ಅಂತ ವಿಶ್ವನಾಥ್ ಆರ್ ಹೆಗಡೆ ಎವಿ ನರಸಿಂಹನ್ both the counsels are absent. This matter of 2 weeks. Mayana Manmohan PN
I request for short
appellant counsel 6 time. Respondent counsel is absent. This matter after 2 weeks. 58. Divya Krishna. Jagdish CM. 58. 57 2 weeks. Both the counsels are absent. List this matter after 2 weeks. No, yes, counsel. This appeal is filed in plaintiff appeal.
Was able to do the execution of the agreement of
Sale
sale
agreement.
again willingness. Once we got that to the defendant. Now, ordered for alternative, ordered for annexation.
Placed money. What is that hardship?
This is the only property awarded to the defendant. But the one of male support male member of the family. Therefore, there will be a hardship compared to the hardship of the client. Therefore, for honest my respectful submission is, my contention is, you have made a suggestion to the defendant number DW1. The defendant number 1, another alternative property measuring 1 hectare 5.
That is admitted.
Subsequently, she denied none of Gottilla, denied of Gottilla, she expressed ignorance. Page number 110. Last line is PW1 is the defendant number 1, defendant number 2. Last line, ನನ್ನ ಅರ್ಜಿಗೆ ಒಂದು ಏಕತೆ
110.
Actually, survey number 32, number 1 and presently 1 letter 5. See, 5 when the that has been updated, but subsequently what the courts have held that those that defendant have taken an intention that there was no other alternative property, there is no other property is the only process. The plaintiff has not filed, does not made an effort to prove that they have an alternative property. So in the first instance, the DW1 has admitted and the archive one way of admitted and better checking not filed any but only on the ground that there was no other alternative property without taking into consideration this application. Then that plaintiff has filed an appeal. Scenario 25/2016, wherein the plaintiff filed an application. Measuring 1 acre 5 guntals and order sheet to show that the suit is pending. But the defendant got file a suit against the plaintiff. But along with order 41/27. That first of all, plaintiff has not made any effort before the trial court. Now he is not entitled to file the additional act. Dismiss the application and confirm the finding of the trial.
Yes, exactly.
Please. The plaintiff has obtained borrowed the loan for the purpose of marriage of the second defendant. That the agreement is 27/2/2022, 2012. The marriage is on 1/3/2012, the span of 3 days. So in that necessity, the urgent is there. The plaintiff has paid 1,95,000 out of 2 lakhs of consideration. Then for the purpose of marriage. They were assured that sale will be expected after the completion of the marriage ceremony. Then the plaintiff has issued a on 10/5/2012. The defendant has replied the notice to content is that they were not executed the sale. It is only Aadhar that mortgage is only mortgage. The trial court has framed the issue number 4 with regard to the defendants prove that whether they have executed only Aadhar Patra, not agreement of sale. That has been negative. That has been paid. So the defendant has been not proved that this is Aadhar Patra. Therefore, the trial court held that this agreement of sale, ready and willingness has been proved. So subsequently, suit has been filed on 6/6/2012.
Substantive question of party.
Justified in rejected the application and Article 41 of petition and proposed additional document to be necessary for complete adjudication. The question of hardship has second, whether the finding by the court below that the respondent should be put to hardship, therefore the specific performance of the agreement cannot be granted based on the evidence.
ಬೇರೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ 41/27 ಅಂತಾರೆ. ಏನದು ಅದಲ್ಲ
Notice was been served, the respondents were not appearing. Then we have made an effort to sell the just to sell this property. Then we put a matter and Karnataka has ordered to serve the notice. Then we take in the hand someone they refused to take. Thereafter they are engaged in counsel. The injunction has been granted by this one.
But the order 41 rule 27 discloses RTC with regard to the other property which is standing in the name of the defendant only.
Subsequently, after dismissal of the suit, dismissal of the appeal, that is
A suit which they have filed against the plaintiff.
after dismissal of the appeal, they are not prosecuted, they have dismissed for now.
Whatever it may be, both the courts comes to the conclusion that there was a sale agreement. Only while appreciating the discretion is concerned, comes to a conclusion that no other property except this property.
Yes.
Yes. One second. ಇದರಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಪೇಪರ್ ಬುಕ್ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಆಯ್ತು ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಆ ಪೇಜ್ ಜಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ 16 to 33 ಪ್ಯಾರಾಗ್ರಾಫ್ ಎಷ್ಟು 33 ನಾ ಹೇಳಿ
Here holder. He has laid like this area. Within their not unhealth be and increasingly can be refused. Then there is absolutely no clear of agreeing with the state. Exam teacher, take some exam as power of attorney. Evidently, he is not able to get treatment either as a witness or identifying the citizen power of attorney. Cannot take it. Not on behalf of the patient or is there event. So that only one, only four, wherein the lawsuit have held contract review, sensitive for the contract, held or has no personal knowledge, cannot be examined, and acts of this case. That fact of here in this case, the defendant has themselves have admitted their signature on they have admitted that step to that.
That has been negative. The contention of the defendant has been negative. GPA holder examine ಮಾಡಿದ ಅವನು ಯಾರು ಅವನು plaintiff ಗೆ related son. Is there any answer illustrate that he is not having any knowledge about this transaction ಬಗ್ಗೆ ನಂಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ಕೊಂಡಿದ್ದೀರಾ ಮತ್ತೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅವಾಗ ಇಲ್ಲ ನಾನು ಅದೆಲ್ಲ ಆ ಪ್ಯಾರ ಎಲ್ಲ ಎಂಟರ್ ಓದಿ ಆಯ್ತು ಆ ಪ್ಯಾರ ಓದಿದ್ದೀನಿ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಆಧಾರ ಪತ್ರ ಅದು ಅನ್ನೋದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ದಿಸ್ ಇಸ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಂತ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಾಟ್ ಪ್ರೂವ್ ದಟ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಅನ್ ಆಧಾರ ಪತ್ರ ಅಂತ
We have got reports. 24 hours paper. 24 hours paper. If the airport has clearly extracted the today's part of the
Double one. Para 18 of the judgment of the trial court. He was having personal knowledge.
Teams of one of the party to the negotiation. So he has personal knowledge about the transaction. Therefore, the fair court negative the contention of the defendant that GP holder cannot be about the.
ಅದೇ ಇರೋದು ನಿಮ್ಗೆ ಇದ್ರಲ್ಲೇ ಮತ್ತೇನ್ ರೇಟ್ ನಾವು crux of the matter is only with regard to whether court can exercise the discretion under section 20. Both the courts comes to the conclusion that only the defendant was having only one property, but the appellate court ought to have received that application under order 41/27 instead of rejecting the same when they have produced the document showing that the defendant is also having other properties other than the suit scheduled property. But the appellate court committed an error in dismissing that application order 41/27. That is the reason only this court has framed the substantive question of law. When the defendant is having other property, how the trial, both the courts can come to a conclusion that the defendant only having only one property. That's why ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಲ್ಲ along with document. ಅಪಲೇಟ್ ಕೋರ್ಟ್ ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತಲ್ವ ಡಾಕ್ಯುಮೆಂಟ್ ನ. ಮತ್ತೆ ಈಗ when they have produced the document along with an application under order 41/27 with RTC, heard the appellant counsel and also the respondent counsel. In part, the respondent counsel seeks time for further arguments. This matter, ನೋಡ್ರಿ next week ಎಲ್ಲ ಕೊಟ್ಟು update disclose ಮಾಡೋಣ next week ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೇಳ್ಬಿಡಿ 20th ಬೇಡ. ನಾನು 20th ಬಹಳಷ್ಟು ಹಾಕೊಂಡಿದ್ದೀನಿ. ಈ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಅದು ಕೊಡ್ತೀನಿ. 16, 17 ಆಯ್ತು 16 ಇದು ನೋಟ್ಸ್ ಹೇಳಿ ಮೇಡಮ್. ಗುರುವಾರ ಆಯ್ತು 15th ಆಯ್ತು. ಯಾವ್ದಾರು ಇದೆಯಾ? 60 ಮಧುಕರ್ ದೇಶಪಾಂಡೆ. ಯಾಕೆ ವೈ ಒನ್ ಟೈಮ್ ಕೌನ್ಸಲ್ 2018. ಏನ್ರಿ ಆರ್ ಯು ರೆಡಿ? ಆಯ್ತು. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time. Respondent counsel is present. Dismiss matter up to 2 weeks. ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಯಾವಾಗ ಮೇಡಮ್ 24 ಕೊಟ್ಟಿರಿ ನೋಡಿ. 23rd ಆಯ್ತು. 23 to ಸಿಂಹ. ನಾಟ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್. ನೀವು ಓದಿದ್ದೀರಾ? ನೀವು ಓದಿಲ್ಲ? ಆಯ್ತು. both the counsel submits that they are not ready after 2 weeks. Just after 2 weeks ಅಷ್ಟೇನಾ? If you are not ready, then after 2 weeks. ಮತ್ತೆ ಓದಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ ಇಬ್ರು? after 2 weeks. ಡೇಟ್ ಹೆಂಗ್ ಫಿಕ್ಸ್ ಮಾಡೋದು? ನಾನು ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ನಂದು ಅಷ್ಟು ಬಿಟ್ಟು ನಾನು ಯಾವ್ದು ಡೇಟ್ ಕೊಡಲ್ಲ. ನಾನ್ ಕೆಲಸ ಮಾಡೋದಾದ್ರೆ ಮಾತ್ರ ನಾನು ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಳ್ಳೋದು. ಆಫ್ಟರ್ 2 weeks ನಿಮ್ಗೆ ಬೇಕಂದ್ರೆ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು. ನಾವ್ ಯಾವ ರೋಸ್ಟರಿಗೆ ಕೂತ್ರು ನಾವು ಮುಂದಿನವ್ರಿಗೆ ಡೇಟ್ ಕೊಡಲ್ಲ. ನನಗೇನಿಲ್ಲ ನೋಡಿ, ಈಗ ನಾನು ಇವತ್ತು ರೆಡಿ ಇದ್ರೆ 4:21 ಹಿಯರ್ ಮಾಡ್ತೀನಿ ಅಪ್ ಟು 4:45. ಆರ್ ಯು ರೆಡಿ? ಐ ವಿಲ್ ಹಿಯರ್. ಇವತ್ತೊಂದು ರಿಸರ್ವ್ ಆಯ್ತಾ? ನಿನ್ನೆ ಒಂದಾ? 2 ಆಯ್ತಾ? ಕಡಿಮೆ ಆಯ್ತು ಅಂತಲ್ಲ? ಎರಡೇ ಏನಲ್ಲ? ನೋಡಿದ್ರೆ 85 ಜನ ನೆನ್ನೆ ಸೇರಿಲ್ಲ. ಹೇಳಿ. ಇರೋ ನಂಬರ್? ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡಿ ಅದ್ ನೋಡಿ ಮೇಡಮ್, ರಿಸರ್ವ್ಡ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ನೋಡಿದ್ರೆ ರಿಸರ್ವ್ ಎಕ್ಸ್ಟೆಂಡ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ. January 1920 ಆದ್ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಪಾರ್ಟ್ ಯಾವಾಗ ಆಗಿದೆ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳೋವರೆಗೂ ಇತ್ತ ಎಂಟ್ರಿ ಮಾಡ್ರು?
ಪಾರ್ಟ್ ಆಗಿರೋ ದಿನ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. ಅದಾದ್ಮೇಲೆ
ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಯಾವತ್ತು ಪಾರ್ಟ್ ಆದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ ನಾನು. ಎಕ್ಸ್ಟೆಂಡೇ ಬರೋದು ರಿಸರ್ವ್ ಒಂದು. ರಿಸರ್ವ್ ಒಂದ್ಮೇಲೆ ಅಷ್ಟೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ನೆಕ್ಸ್ಟ್ ಅಷ್ಟೇ.
ಇದೊಂದು ಅದು ರಿಸರ್ವ್